Paper, Criminal Procedure Code / Bhartiya Nagarik Suraksha Sanhita 1 Question 1. Constitution and powers of criminal courts. Explain the constitution and powers of the criminal courts under the Code of Criminal Procedure Code, 1973, or relevant corresponding provisions of BNSS, 2023. Constitution of Criminal Courts under the CrPC, 1973. The Code of Criminal Procedure, 1973 establishes a hierarchical structure of criminal courts to adjudicate offenses, ensuring a systematic approach to justice delivery. Section 6 of the Code of Criminal Procedure, 1973 classifies criminal courts, excluding high courts and courts constituted under special laws, into the following categories. 1. Courts of Session, established under Section 9, these courts operate at the district level, presided over by a sessions judge appointed by the High Court. Additional and assistant sessions judges may also be appointed to exercise jurisdiction within the same sessions division. 2. Courts of Judicial Magistrates, as per Section 11, these include Courts of Chief Judicial Magistrates, CJMs, Judicial Magistrates of the First Class, JMFC, and Judicial Magistrates of the Second Class, JMSC, established in districts as notified by the state government in consultation with the High Court. 3. Courts of Metropolitan Magistrates, under Section 16, these courts function in metropolitan areas, with a chief metropolitan magistrate overseeing their operations. 4. Executive Magistrates, appointed under Section 20, these include district magistrates, subdivisional magistrates, and other executive magistrates, tasked with maintaining public order and performing administrative functions. 5. Special Courts, Sections 12-14 allow for the appointment of special judicial magistrates and special executive magistrates for specific cases or functions, ensuring flexibility in addressing local needs. For instance, in a case of murder under Section 302 of the Indian Penal Code, 1860, IPC, the trial is typically conducted by a court of session, as it is exclusively triable by such courts. First Schedule, the Code of Criminal Procedure, 1973. However, preliminary inquiries or bail applications may be handled by a judicial magistrate before committal to the Sessions Court. The retains a similar hierarchical structure under Section 6, with notable exclusions such as the removal of metropolitan courts, reflecting an intent to simplify judicial administration. Section 8 of the reinforces the role of sessions courts, while Sections 9-11 outline the establishment of judicial magistrates, aligning with the Code of Criminal Procedure, 1973 BUT, introducing procedural enhancements like mandatory forensic investigations for serious offenses. 2. Landmark Case, Husainara Khatun v. State of Bihar, 1979, the Supreme Court in Husainara Khatun v. State of Bihar, Air 1979 SC 1360, emphasized the role of criminal courts in ensuring speedy trials, a constitutional mandate under Article 21. The case exposed delays in trials due to overburdened courts, prompting reforms in judicial administration. The addresses such concerns by mandating electronic trials under Section 530, aiming to expedite proceedings. Powers of criminal courts under the CrPC, 1973. The powers of criminal courts under the Code of Criminal Procedure, 1973 are delineated in Chapter 3, Sections 26-35, encompassing jurisdiction, sentencing, and procedural authority. These powers are designed to balance judicial discretion with statutory limits, ensuring fairness and accountability. Jurisdictional powers. Courts of Session, Section 26. These courts have original, appellate, and revisional jurisdiction. They try offenses punishable with death, life imprisonment, or imprisonment exceeding 7 years. For example, in Bakhan Singh v. State of Punjab, Air 1980 SC 898, the Supreme Court upheld the Sessions Court's jurisdiction to impose the death penalty, subject to the rarest of rare doctrine. Judicial Magistrates, Section 2829. The CJM can try offenses not exclusively triable by Sessions Courts, while JMFCs handle cases punishable with up to 3 years imprisonment, and JMSCs up to 1 year. For instance, a JMFC may try a case of theft under Section 379, IPC. Executive Magistrates, Section 107-145. These magistrates exercise preventive powers to maintain public peace, such as issuing orders under Section 144 to prohibit public gatherings. In Ram Manohar Lohia v. State of Bihar, Air 1966 SC 740, the Supreme Court clarified the limits of such powers to prevent misuse. Under the Sections 21-29 govern the powers of courts, retaining the jurisdictional framework of the Code of Criminal Procedure, 1973. However, Section 21 mandates that offences under Section 6471 of the Bhartiya Nagarik Sanhita, 2023, BNSS, related to crimes against women, be tried by courts presided over by women judges, enhancing gender sensitivity in judicial proceedings. Sentencing powers. The Code of Criminal Procedure, 1973 specifies sentencing limits for each court. Sessions Court, Section 28 can impose any sentence authorized by law, including death, subject to confirmation by the High Court. 3. Chief Judicial Magistrate, Section 29 may impose imprisonment up to 7 years and fines without limit, unless specified. Judicial Magistrate First Class, Section 29 can impose imprisonment up to 3 years or a fine up to 10,000 rupees. Judicial Magistrate Second Class, Section 29 limited to 1 year's imprisonment or a fine up to 5,000 rupees. In State of NCT of Delhi v. Sanjay, 2014, 9 SCC 772, the Supreme Court clarified the sentencing powers of magistrates, emphasizing proportionality. The enhances these limits under Section 23, increasing the fine for JMFCs to 50,000 rupees and for JMSCs to 10,000 rupees, reflecting inflationary adjustments and deterrence objectives. Procedural powers. Criminal courts under the Code of Criminal Procedure, 1973 exercise various procedural powers, including cognizance of offences. Sections 190-199 magistrates can take cognizance of offences upon complaint, police report, or suo motu. In Lalita Kumari v. Government of UP, 2014, 2 SCC 1, the Supreme Court mandated for registration for cognizable offences, reinforcing magistrates' oversight. Bail and bonds. Sections 436-439 courts grant bail based on the nature of the offence. The expands bail provisions, ensuring absolute rights for bailable offences. Attachment and forfeiture. Sections 80-86 courts may attach property of absconding offenders. The introduces interim attachment powers, raising concerns about due process, as noted in AZB Partners Analysis, 2023. Landmark Case, D.K. Basu v. State of West Bengal, 1997, in D.K. Basu v. State of West Bengal, Air 1997 SC 610, the Supreme Court issued guidelines to prevent custodial torture, emphasizing the role of magistrates in safeguarding arrested persons' rights under Section 57 of the Code of Criminal Procedure, 1973. The incorporates these safeguards under Section 58, mandating information to relatives about arrests, aligning with constitutional protections under Article 22. Comparative analysis with the Bhartiya Nagarik Suraksha Sanhita, 2023. The introduces several reforms to address challenges like case backlogs and delays, as highlighted in Husainara Khatun. Key changes include, forensic investigation, Section 176 mandatory for offences punishable with 7 years or more, enhancing evidence collection for electronic trials. Section 530 allows virtual proceedings to expedite justice delivery. Trial in absentia. Section 356 permits trials of proclaimed offenders who abscond, balancing efficiency with fairness. Data collection. Section 105 expands evidence to include digital records and voice samples, raising privacy concerns, as noted in Supreme Court hearings on digital device seizures, 2023. While the aims to modernize criminal procedure, provisions like staggered police custody, Section 187, have drawn criticism for potentially undermining bail rights, as argued in a 2024 Supreme Court petition, Anjal Patel v. Union of India. The retention of Section 144 powers under the also raises concerns about colonial legacies, necessitating judicial oversight to prevent misuse. 5. Question 2. Short notes on offences and cases. Write a short note on the followings: a. Cognizable and non-cognizable offences. b. Warrant and summons cases. c. Bailable and non-bailable. d. Compoundable and non-compoundable. A. Cognizable and non-cognizable offences. Under the BNSS, offences are classified into cognizable and non-cognizable categories to delineate the scope of police authority in investigation and arrest. According to Section 2, G, a cognizable offense is one where a police officer may arrest without a warrant and initiate an investigation without a magistrate's prior approval, as specified in the first schedule of the BNSS or any other applicable law. These offenses are typically serious, requiring immediate action due to their impact on public order or safety. Examples include murder, Section 103 of the Bhartiya Nagarik Sanhita, 2023 BNS, rape, Section 64, BNS, and kidnapping, Section 137, BNS. In contrast, Section 2.0 defines a non-cognizable offense as one where a police officer cannot arrest or investigate without a magistrate's order, as per Section 174.2. These are generally less severe offenses, such as defamation, Section 356, BNS, or simple hurt, Section 331, BNS. For cognizable offenses, Section 173.3 allows a police officer to conduct a preliminary inquiry for offenses punishable with imprisonment of 3 to 7 years to ascertain a prima facie case before registering a first information report, FIR. The FIR, under Section 173.1, can be lodged orally or electronically, and if electronic, must be signed within 3 days. For instance, in a case of theft, Section 317, BNS, a victim can report to the police, who may arrest the accused immediately and begin investigation. Conversely, non-cognizable offenses require a complainant to approach a magistrate under Section 175.3, if the police refuse to act. For example, in a case of public nuisance, Section 351, BNS, the police cannot act without a magistrate's directive. A pivotal case illustrating the distinction is Lalita Kumari v. Government of Uttar Pradesh, 2014. The Supreme Court held that registration of an FIR is mandatory for cognizable offences upon receiving information, except in cases requiring preliminary inquiry, which the BNSS now codifies under Section 173.3. However, the BNSS's provision allowing preliminary inquiries for certain cognizable offences, 3 to 7 years imprisonment, has sparked debate, as it may conflict with the Lalita Kumari ruling by granting police discretion to delay for registration, potentially leading to misuse. In State of Haryana v. Bajan Lal, 1992, the court established guidelines for preliminary inquiries in non-cognizable offences, emphasizing that police must seek magistrate approval before acting, reinforcing procedural safeguards. The classification ensures swift action for serious crimes while preventing arbitrary arrests in minor cases. However, the BNSS's expansion of preliminary inquiries for cognizable offences may delay justice, necessitating judicial oversight to balance police powers and individual rights. 6b. Warrant and summons cases. The BNSS categorizes criminal cases into warrant and summons cases based on the severity of punishment and procedural requirements, as outlined in the first schedule. Section 2.W defines a warrant case as one relating to an offense punishable with death, imprisonment for life, or imprisonment exceeding 2 years. Examples include murder, Section 103, BNS, and robbery, Section 310, BNS. A summons case, under Section 2, B, pertains to offenses punishable with imprisonment of 2 years or less, a fine, or both, such as petty theft, Section 317, BNS, or public nuisance, Section 351, BNS. Warrant cases follow a more rigorous procedure due to their gravity. Under Section 227, a magistrate may issue a warrant or summons to secure the accused appearance, with electronic issuance now permitted. The trial process, detailed in Chapter XX, involves framing formal charges, recording evidence, and a structured examination of the accused. For instance, in a robbery case, the magistrate frames charges under Section 232, and the prosecution must prove guilt beyond reasonable doubt. Summons cases, governed by Chapter 19, are simpler, with no mandatory charge framing. Section 223 requires the accused to be informed of the offense and plead guilty or present a defense, as seen in cases of minor traffic violations. The BNSS introduces timelines to reduce delays. Section 263 allows a magistrate to discharge the accused in a summons case or a complaint-initiated warrant case, if compoundable or non-cognizable, if the complainant fails to appear within 30 days, a provision absent in the CrPC. This aims to curb frivolous complaints, as illustrated in a hypothetical case where a complainant files a false public nuisance claim but fails to pursue it. In K.M. Matthew v. State of Kerala, 1992, the Supreme Court clarified that magistrates have discretion in summons cases to drop proceedings if the complainant's absence indicates mala fide intent, a principle now codified in the BNSS. For warrant cases, Adalat Prasad v. Rupal Jindal, 2004, emphasized that magistrates cannot recall summons or warrants without legal basis, underscoring procedural rigor. The BNSS retains these judicial principles while enhancing efficiency through electronic processes and timelines. The distinction ensures that serious offenses receive thorough judicial scrutiny, while minor cases are resolved expeditiously, aligning with the BNSS's goal of reducing case backlogs. See bailable and non-bailable offenses. Section 2, C, of the BNSS defines a bailable offense as one listed as bailable in the first schedule or made bailable by other laws, granting the accused an absolute right to bail. Examples include simple hurt, Section 331, BNS, and criminal trespass, Section 351, BNS. A non-bailable offense is any other offense, where bail is discretionary and subject to judicial scrutiny, such as murder, Section 103, BNS, or rape, Section 64, BNS. In bailable offenses, Section 479 mandates that bail be granted by the police or court as a matter of right, typically upon furnishing a bail bond with or without sureties. For instance, an accused in a case of public nuisance can secure bail from the police station. In non-bailable offenses, Section 480 allows courts to grant bail based on factors like the offense's severity, evidence, and the accused criminal history. The BNSS retains the CrPC's framework but introduces stricter 7 conditions for certain offenses, such as terrorism, Section 111, BNS, where bail is rarely granted. The Supreme Court in Arnish Kumar v. State of Bihar, 2014, ruled that arrests in offenses punishable with less than 7 years imprisonment should be an exception, emphasizing bail as a right in bailable offenses and cautioning against arbitrary arrests. For non-bailable offenses, Gurbakshir Singh Sibia v. State of Punjab, 1980, established guidelines for anticipatory bail under Section 482, highlighting that courts must balance individual liberty with societal interests. The BNSS incorporates these principles, ensuring bail decisions are reasoned and transparent. The bailable and non-bailable distinction protects individual rights while allowing judicial discretion in serious cases. The BNSS's emphasis on mandatory bail in bailable offenses reduces unnecessary detention, but challenges like judicial backlog persist, requiring further reforms. Decompoundable and non-compoundable offenses. Compoundable offenses are those that can be settled between the parties with or without court permission, as listed in the first schedule or other laws. Section 359 governs compounding, allowing the complainant and accused to resolve disputes, typically in less severe cases like cheating. Section 318, BNS, or criminal trespass. Section 351, BNS. Non-compoundable offenses, such as murder or rape, cannot be settled privately due to their grave nature and public interest implications. For compoundable offenses, Section 359, 2, specifies that certain offenses, like theft, require court permission, while others, like minor assaults, do not. The BNSS retains the CrPC's plea bargaining framework under Section 293, allowing sentence bargaining for offenses not punishable with death, life imprisonment, or over 7 years imprisonment. However, a new 30-day limit for filing plea bargaining applications may restrict its effectiveness. For example, in a case of cheating, the accused may plead guilty for a reduced sentence, subject to court approval. In Gian Singh v. State of Punjab, 2012, the Supreme Court held that compoundable offenses can be quashed under Section 528, equivalent to CrPC Section 482, if settlement serves justice, but non-compoundable offenses, especially heinous ones, cannot be compromised. This principle guides BNSS application, ensuring public interest is safeguarded. In State of Madhya Pradesh v. Laxmi Narayan, 2019, the court clarified that compounding in non-compoundable offenses is permissible only in exceptional cases, such as matrimonial disputes, where settlement aligns with justice. Compounding promotes restorative justice, reducing court burden, but the BNSS's time limits and restrictions on plea bargaining may limit its scope. Non-compoundable offenses ensure accountability for serious crimes, reflecting the state's commitment to public safety. Conclusion: the BNSS, 2023, modernizes India's criminal procedure by refining the classification and handling of offenses. Cognizable and non-cognizable offenses delineate police powers, with cases like Lalita Kumari ensuring mandatory for registration for serious crimes. Warrant and summons cases balance procedural rigor with efficiency, as seen in K.M. Matthew. Bailable and non-bailable offenses protect individual rights while allowing judicial discretion, guided by Arnish Kumar. Com-8-poundable and non-compoundable offenses promote restorative justice within limits, as per Gian Singh. These reforms, supported by technology and timelines, aim to enhance justice delivery, though challenges like potential misuse of preliminary inquiries and judicial backlogs require ongoing scrutiny. 9. Question 3. Police powers of investigation and arrest. State the powers of police officer to investigate. When can a police officer arrest a person without the permission of magistrate or without a warrant? Explain. Powers of police officers to investigate under the BNSS. The BNSS outlines the procedural framework for criminal investigations in India, emphasizing efficiency, technological integration, and accountability. The powers of police officers to investigate are primarily governed by Chapter 13, Sections 172 to 211, of the BNSS, which detail the process from the registration of a First Information Report, FIR, to the submission of a police report. Below is a comprehensive analysis of these powers, supported by examples and judicial interpretations. 1. Registration of FIR. Under Section 173, 1, of the BNSS, a police officer is mandated to register an FIR upon receiving information about a cognizable offense. This provision ensures that investigations commence promptly for serious crimes. The FIR must be recorded in the prescribed Integrated Investigation Form IIFI, and signed by the investigating officer. The BNSS introduces electronic filing of FIRs, allowing complaints to be lodged via electronic communication, which must be signed within 3 days, Section 173, 1. Example: if a citizen reports a robbery at a local shop, the police officer at the station must register an FIR under Section 173, 1, if the offense is cognizable, such as robbery under Section 309 of the Bhartiya Nagarik Sanhita, 2023, BNS. Case law, in Lalita Kumari v. Government of Uttar Pradesh, 2014, 2 SCC 1, the Supreme Court held that registration of an FIR is mandatory for cognizable offences, and any preliminary inquiry must be completed within 7 days to prevent delays. This principle is reflected in Section 173, 3, of the BNSS, which allows a preliminary inquiry with the permission of a senior officer to ascertain a prima facie case. 2. Examination of witnesses. Section 180 of the BNSS empowers police officers to examine witnesses during an investigation. The investigating officer may issue a notice under Section 179 to summon witnesses to the police station for recording statements. These statements can be recorded using audio-video means, enhancing transparency, Section 180, 3. Example, in a murder investigation, the police officer may summon neighbors who witnessed suspicious activity near the crime scene to record their statements under Section 180. 3. Search and seizure. Police officers have the authority to conduct searches and seize evidence under Sections 184 and 185 of the BNSS. Section 184 governs searches with a warrant, while Section 185 allows searches without a warrant in urgent situations, provided the officer records reasons in writing. The BNSS 10 mandates that searches be recorded using audio-video means and that records be sent to the nearest magistrate within 48 hours, Section 185, 5. Example, if a police officer receives credible information about stolen goods hidden in a warehouse, they may conduct a warrantless search under Section 185, provided the reasons are documented and the search is recorded. Case law, in State of Punjab v. Balbir Singh, 1994, 3 SCC 299, the Supreme Court emphasized that searches without a warrant must comply with procedural safeguards to prevent abuse. This principle is codified in Section 185 of the BNSS, ensuring accountability. 4. Forensic investigation for offenses punishable with 7 years or more of imprisonment, Section 176, 3, of the BNSS mandates forensic investigation. Forensic experts must visit crime scenes to collect evidence, and the process must be recorded. This provision enhances the scientific rigor of investigations. Example, in a case of aggravated assault, Section 109 BNS, forensic experts may collect DNA evidence from the crime scene, which must be documented as per Section 176, 3. 5. Collection of evidence. The BNSS expands the scope of evidence collection under the Criminal Procedure, Identification, Act, 2022, incorporated into the BNSS framework. Police officers can collect fingerprints, voice samples, and other biometric data for investigation, Section 180, 4. Additionally, courts or police officers can compel the production of electronic devices likely to contain digital evidence, Section 530. Example, in a cybercrime case, the police may seize a suspect's laptop under Section 530 to recover digital evidence, such as hacking logs. 6. Further investigation. Section 193, 9, of the BNSS allows police officers to conduct further investigation after filing a charge sheet, provided it is completed within 90 days, unless extended by the court. This ensures that investigations remain thorough without undue delays. Example, if new evidence emerges after filing a charge sheet in a theft case, the police may investigate further within the 90-day limit under Section 193, 9. 7. Timelines and accountability. The BNSS introduces strict timelines to enhance efficiency. For instance, the FIR must be forwarded to the Chief Metropolitan or Judicial Magistrate within 24 hours of registration, Section 173, 1. Additionally, Section 187, 2, limits police custody to 15 days, either in one stretch or in parts, within the first 40 or 60 days of detention, depending on the offense's severity. Case law, in Arnish Kumar v. State of Bihar, 2014, 8 SCC 273, the Supreme Court ruled that arrests must be justified with recorded reasons to prevent arbitrary detention. This principle 11 is reinforced in Section 35(3) of the BNSS, which requires written reasons for arrests without a warrant. Arrest without magistrate's permission or warrant. The BNSS categorizes offenses into cognizable and non-cognizable, with the first schedule specifying whether an offense is cognizable, bailable, or compoundable. Cognizable offenses allow police officers to arrest without a warrant or magistrate's permission, while non-cognizable offenses generally require such authorization. Section 35 of the BNSS, which consolidates provisions equivalent to Sections 41 and 41A of the CrPC, outlines the circumstances under which a police officer may arrest without a warrant. Circumstances for arrest without warrant, Section 35(1). A police officer may arrest a person without a warrant in the following situations: a. Offense committed in presence, when a person commits a cognizable offense in the presence of a police officer, Section 35(1). A. Example, if a police officer witnesses a person committing robbery in a marketplace, they can arrest the individual immediately under Section 35(1). A. B. Credible information or reasonable suspicion, when there is a reasonable complaint, credible information, or reasonable suspicion that a person has committed a cognizable offense punishable with imprisonment up to 7 years, provided the officer believes the arrest is necessary for preventing further offenses. Ensuring proper investigation. Preventing evidence tampering. Preventing inducement, threat, or promise to witnesses. Ensuring the accused presence in court. The officer must record the reasons for the arrest in writing, Section 35(3). Example, if the police receive a tip that a person is planning a burglary, a cognizable offense under Section 309 BNS, they may arrest the suspect under Section 35(1)(b), after documenting the reasons. C. Serious cognizable offenses. For cognizable offenses punishable with imprisonment exceeding 7 years, a police officer may arrest without a warrant based on reasonable suspicion or credible information, without the additional conditions required for lesser offenses. Example, in a murder case, Section 103 BNS, the police may arrest a suspect based on witness testimony without a warrant. 12. D. Proclaimed offenders. A police officer may arrest a proclaimed offender or a person accused of a non-bailable offense who is evading arrest, Section 35(1) c. Example, if a person declared a proclaimed offender under Section 84 BNSS absconds, the police can arrest them without a warrant. E. Requisition from another officer. When a police officer receives a written requisition from another officer specifying the person and offense, they may arrest without a warrant, Section 35(1) e. Example, if a police station in Delhi issues a requisition to arrest a suspect in a hit-and-run case, a Mumbai police officer can execute the arrest under Section 35(1) e. Safeguards and restrictions. The BNSS incorporates safeguards to prevent misuse of arrest powers, Section 35(7). No arrest shall be made without the prior permission of an officer not below the rank of Deputy Superintendent of Police for offenses punishable with less than 3 years imprisonment if the person is infirm or above 60 years of age. Example, an elderly person suspected of a minor theft, punishable with less than 3 years, cannot be arrested without senior officer approval. Notice of appearance. Under Section 35(3), instead of arresting, the police may issue a notice to appear for offenses punishable with less than 7 years, as seen in Tavaragi Rajashekar Shiva Prasad v. State of Karnataka, Karnataka High Court, 2024, where the court mandated that notices under Section 35 include the crime number and fur copy. Recording reasons. The requirement to record reasons for arrest, Section 35(3), ensures accountability and aligns with the Supreme Court's directive in Arnish Kumar v. State of Bihar, 2014, 8 SCC 273. Time limit for detention, Section 57 of the CrPC, mirrored in the BNSS, prohibits detention beyond 24 hours without magistrate approval, exclusive of travel time. Judicial oversight and rights of the arrested. The BNSS emphasizes the rights of arrested persons to prevent arbitrary detention. Information of grounds. The police must inform the arrested person of the grounds of arrest and present the warrant, if any, Section 50 BNSS. Communication to family. The BNSS mandates prompt communication of the arrest to the arrested person's family or nominee, Section 50. Right to legal counsel. The arrested person has the right to consult a lawyer of their choice, Section 50. 13. Medical examination. Section 54 BNSS requires a medical examination of the arrested person to document injuries or health conditions. Case law. In D.K. Basu v. State of West Bengal, 1997, 1 SCC 416, the Supreme Court laid down guidelines for arrests, including the right to be informed of grounds and the preparation of an arrest memo. These guidelines are incorporated into the BNSS to ensure compliance with Article 21. Critical analysis. The BNSS strikes a balance between empowering police officers and protecting individual liberties. The introduction of forensic investigations, electronic recording, and strict timelines reflects a modern approach to criminal justice. However, concerns remain about potential misuse of powers, particularly in warrantless arrests for offenses punishable with less than 7 years. The requirement for senior officer approval for certain arrests, Section 35(7), and the emphasis on recording reasons are steps toward accountability, but their implementation depends on effective training and oversight. The provision for trial in absentia, Section 356 BNSS, for proclaimed offenders raises constitutional questions under Article 21, as it may infringe on the right to a fair trial. Additionally, the broad power to collect biometric and digital evidence under Section 180(4) and Section 530 must be exercised cautiously to avoid violating privacy rights, especially in light of K.S. Puttaswamy v. Union of India, 2017, 10 SCC 1, which recognized the right to privacy as a fundamental right. 14. Question 4, Charge and its contents. What do you understand by charge? Explain the contents of charge. Understanding the concept of charge. A charge, under the BNSS, is a precise statement of the allegations against the accused, outlining the specific offense, they are alleged to have committed. It is a critical procedural step that bridges the investigation and trial phases, ensuring the accused is informed of the accusations to exercise their right to a fair defense. The charge transforms the general findings of a police investigation or complaint into specific legal accusations, enabling the court to frame the issues for trial. The BNSS governs the framing, contents, and alteration of charges under Chapter 16, Sections 246 to 267, aligning with the principles of natural justice and due process. The concept of a charge is rooted in the principle that the accused must know the precise nature of the accusations to respond effectively. A defective or vague charge can vitiate the trial, as it may prejudice the accused defense, violating Article 21's guarantee of a fair trial. The Supreme Court, in Ishar Singh v. State of Andhra Pradesh, 2004, 11 SCC 585, emphasized that a charge must be clear and specific to avoid prejudice, a principle reflected in the BNSS provisions. Example, in a case of theft under Section 303 of the Bhartiya Nagarik Sanhita, 2023, BNS, the charge would specify that the accused stole a specific item, e.g., a gold necklace, from a particular person at a given time and place, enabling the accused to prepare a defense against these allegations. Provisions governing charge under the BNSS. The BNSS outlines the procedural framework for charges in Sections 246 to 267, which correspond to sections 211 to 224 of the CrPC but incorporate modern procedural enhancements. Key provisions include, Section 246, defines the contents of a charge and mandates that it be framed in writing. Section 247, specifies the particulars of time, place, and person in the charge. Section 248, addresses the manner of stating the offense and its particulars. Section 251, allows joinder of charges for multiple offenses in certain cases. Section 254, permits alteration or addition of charges during the trial. Section 267, addresses the effect of errors in the charge. These provisions ensure that the charge is precise, transparent, and adaptable to the needs of justice, balancing the prosecution's need to present its case with the accused's right to a fair trial. 15. Contents of a charge under the BNSS. The contents of a charge are meticulously detailed in the BNSS to ensure clarity and fairness. Section 246, 1. Mandates that a charge must be written in the language of the court and contain specific particulars to inform the accused of the allegations. The essential contents of a charge, as per sections 246 to 248, are discussed below. 1. Statement of the offense. The charge must clearly state the offense with which the accused is charged, specifying the name of the offense as defined in the law, such as the Bhartiya Nagarik Sanhita, 2023, BNS, or other penal statutes. If the offense has a specific name, e.g., murder under section 103 BNS, the charge should use that name. If no specific name exists, the charge must describe the offense or cite the legal provision violated, section 246, 2. Example, for an accusation of cheating under section 316 BNS, the charge would state, the accused is charged with the offense of cheating under section 316 of the Bhartiya Nagarik Sanhita, 2023. Case law, in State of West Bengal v. Lesalhak, 1989, 3 SCC 166, the Supreme Court held that the charge must specify the offense clearly to avoid ambiguity, ensuring the accused understands the allegations. 2. Particulars of time and place. Section 247 requires the charge to include the time and place of the alleged offense. These particulars enable the accused to verify alibis or contest the prosecution's narrative. The time and place need not be exact to the minute or precise location but must be sufficiently specific to avoid prejudice. Example, in a robbery case, the charge might state, the accused, on or about June 5, 2025, at approximately 8 p.m., committed robbery at shop number 12, MG Road, Mumbai. 3. Particulars of the person affected. The charge must specify the person against whom the offense was committed, if applicable, or describe the property involved. This ensures the accused knows the victim or subject of the offense. Example, in a case of assault, section 109 BNS, the charge would state, the accused assaulted Mr. Ramesh Kumar, resident of 45, Vasant Vihar, Delhi, causing grievous hurt. 4. Manner of commission. Section 248 requires the charge to describe the manner in which the offense was committed, providing sufficient detail to inform the accused of the prosecution's case. This includes the specific acts or omissions constituting the offense. 16. Example, for a charge of criminal breach of trust, section 314 BNS, the charge might state, the accused, being a cashier at XYZ Bank, misappropriated Rs 5,00,000 entrusted to them by withdrawing funds without authorization. Case law, in V.C. Shukla v. State, 1980, 2 SCC 665, the Supreme Court ruled that the charge must include sufficient particulars to enable the accused to understand the prosecution's case, reinforcing the importance of Section 248. 5. Legal provisions violated. The charge must cite the specific section of the law violated, such as the BNS or other penal statutes, to establish the legal basis of the accusation. If the offense is defined by a specific provision, the charge must reference it, Section 246, 3. Example, in a case of forgery, Section 336 BNS, the charge would state, the accused committed forgery by falsifying a sale deed, punishable under Section 336 of the Bhartiya Nagarik Sanhita, 2023. 6. Joinder of charges. Section 251 allows multiple charges to be framed in a single trial for offenses committed in one series of acts or forming part of the same transaction. This prevents multiplicity of proceedings while ensuring fairness. Example, if an accused commits theft and assault during a single robbery incident, the charge may include both offenses under Sections 303 and 109 BNS, respectively, as part of the same transaction. Case law, in State of Andhra Pradesh v. Chimalapati Gainswara Rao, 1963, 3 SCR 297, the Supreme Court clarified that joinder of charges is permissible if the offenses are connected, a principle codified in Section 251 BNSS. 7. Language and form. The charge must be written in the language of the court, Section 246, 1, and framed in a prescribed form, as specified in the BNSS schedules. The language should be clear and precise to avoid ambiguity. Example, a charge for murder might be framed as, that you, on or about June 10, 2025, at 123, Park Street, Kolkata, caused the death of Mr. Anil Sharma by stabbing him with a knife, thereby committing an offence of murder punishable under Section 103 of the Bhartiya Nagarik Sanhita, 2023. Procedure for framing a charge. The process of framing a charge under the BNSS involves several procedural steps to ensure fairness. 17.1. Investigation and police report. After investigation, the police submit a report under Section 193 BNSS, indicating whether there is sufficient evidence to frame a charge. 2. Consideration by magistrate. In warrant cases, the magistrate examines the police report and evidence under Section 262 BNSS to determine if a charge should be framed. 3. Reading and explanation. The charge is read and explained to the accused in open court, Section 249, ensuring they understand the allegations. 4. Plea of the accused. The accused is asked to plead guilty or not guilty, Section 250. If they plead guilty, the court may convict them. Otherwise, the trial proceeds. 5. Alteration of charge. Section 254 allows the court to alter or again add to the charge at any stage before judgment, provided the accused is not prejudiced. Case law, in Kantilal Shantilal Mehta v. State of Maharashtra, 1969, 3 SCC 166, the Supreme Court held that any alteration of a charge must not prejudice the accused, a safeguard retained in Section 254 BNSS. Effect of errors in a charge. Section 267 of the BNSS provides that no error or omission in a charge shall vitiate the trial unless it materially prejudices the accused. This provision balances procedural flexibility with fairness, allowing courts to overlook minor defects that do not affect the trial's outcome. Example, if a charge incorrectly cites Section 304 BNS instead of Section 303 BNS but the particulars clearly describe theft, the error may not invalidate the trial if the accused was not misled. Case law, in William, Slaney v. State of Madhya Pradesh, 1955, 2 SCR 1140, the Supreme Court ruled that an error in a charge is not fatal unless it causes a miscarriage of justice. This principle is codified in Section 267 BNSS. Judicial safeguards and constitutional protections. The framing of a charge under the BNSS is subject to constitutional safeguards under Articles 20, 21, and 22 of the Indian Constitution. Article 20, 3, protects against self-incrimination, ensuring the accused is not compelled to plead guilty. Article 21 guarantees a fair trial, requiring the charge to be clear and specific. Article 22 mandates that the accused be informed of the grounds of arrest, which aligns with the requirement to read and explain the charge. Case law, in Nandini Satpathy v. P.L. Dani, 1978, 2 SCC 424, the Supreme Court emphasized the right to silence, which extends to the stage of framing a charge, ensuring the accused is not coerced into pleading guilty. Critical analysis. The BNSS enhances the procedural framework for charges by emphasizing clarity, specificity, and flexibility. The inclusion of digital documentation, e.g., audio-video recording of proceedings, and 18 strict timelines reflects a modern approach to criminal justice. However, challenges remain, such as ensuring that charges are framed without undue delay, particularly in complex cases involving multiple offenses. The joinder of charges under Section 251, while efficient, must be applied cautiously to avoid overwhelming the accused with multiple allegations, potentially violating fair trial principles. Moreover, the reliance on police reports for framing charges raises concerns about investigative biases, as highlighted in H. N. Rishput v. State of Delhi, 1955, 1 SCR 1150, where the Supreme Court cautioned against defective investigations affecting trial fairness. The BNSS addresses this by mandating forensic investigations for serious offenses, Section 176, 3, but effective implementation requires robust training and infrastructure. 19. Question 5. Trial and local jurisdiction. What is trial? Every offense is ordinarily tried by the same court within whose local jurisdiction the offense is committed. Discuss the statement. Defining trial under the BNSS. The BNSS, under Section 2, K, defines an inquiry as distinct from a trial, stating that an inquiry includes every proceeding other than a trial conducted by a magistrate or court. While the BNSS does not explicitly define trial, it can be inferred from its provisions and the CrPC's legacy that a trial is a judicial proceeding where evidence is legally taken on oath to determine the guilt or innocence of the accused. This process involves examining witnesses, assessing evidence, and delivering a judgment, as outlined in Chapters 18 to XXII of the BNSS, which detail procedures for trials before magistrates and courts of session. A trial is distinct from an investigation, which, under Section 2, L, involves evidence collection by police or authorized persons, and an inquiry, which may precede or follow a trial. For instance, a trial commences after the framing of charges, Section 248 for sessions trials, and concludes with a judgment, Section 392. The BNSS categorizes trials into summons case trials, Sections 279-283 for offenses punishable with imprisonment up to 2 years, such as theft under Section 303 of the Bhartiya Nagarik Sanhita, 2023, BNS, where the stolen property's value is less than 200,000. Warrant case trials, Sections 265-278 for offenses punishable with death, life imprisonment, or terms exceeding 2 years, such as murder under Section 103 of the BNS. Summary trials, Sections 283-287 for minor offenses, allowing expeditious disposal with imprisonment not exceeding 3 months. Sessions trials, Sections 248-264 conducted by courts of session for serious offenses, with prosecution led by a public prosecutor, Section 248. Consider a case of criminal intimidation under Section 349 of the BNS, punishable with up to 2 years imprisonment. If prosecuted as a summons case, the trial involves the accused pleading guilty or not guilty, followed by evidence presentation and judgment. If the accused pleads guilty, the magistrate may convict without a full trial, Section 281, demonstrating the BNSS's emphasis on efficiency. Jurisdiction, the general principle. Section 199 of the BNSS establishes the foundational rule that every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. This principle ensures that, 1. The court is geographically proximate to the crime scene, facilitating access to evidence and witnesses. 22. The community affected by the offense participates in the justice process, enhancing public trust. 3. Logistical challenges, such as transporting witnesses or evidence, are minimized. Section 199, 1, states, every offense shall ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. The term local jurisdiction is defined under Section 2, n, as the area within which a court or magistrate may exercise its powers, as notified by the state government. For example, if a robbery occurs in New Delhi, the judicial magistrate of the first class in the relevant district would typically have jurisdiction. The BNSS, under Section 620, outlines the hierarchy of criminal courts. Courts of session handle serious offenses like murder or dacoity, presided over by a sessions judge, Section 8. Judicial magistrates, first and second class magistrates try less serious offenses, Sections 9-12. Executive magistrates handle preventive measures and certain inquiries, Sections 14-17. High courts and Supreme Court exercise appellate and inherent jurisdiction, Sections 401-406. Suppose a theft occurs in Mumbai's Bandra area. The local judicial magistrate in Mumbai would have jurisdiction under Section 199. The police would file a first information report, FIR, under Section 173, and the trial would proceed in the magistrate's court, ensuring proximity to the crime scene and witnesses. Exceptions to the general principle. While Section 199 establishes the default rule, the BNSS provides exceptions to accommodate complex scenarios, such as offenses committed across multiple jurisdictions, continuing offenses, or cybercrimes. These exceptions are detailed in Sections 200-206. Offenses committed across multiple jurisdictions. Section 200 addresses cases where an offense is committed partly in one jurisdiction and partly in another. The court in any of the jurisdictions where an act constituting the offense occurred may try the case. For example, if a conspiracy to commit murder is planned in Kolkata but executed in Chennai, courts in either city may have jurisdiction. Continuing offenses. Section 201 covers continuing offenses, such as kidnapping, where the offense begins in one jurisdiction and continues in another. The court in any jurisdiction where the offense was committed or continued may try the case. For instance, if a person is kidnapped in Delhi and transported to Haryana, courts in either state could assume jurisdiction. 21. Cybercrimes and electronic communication. The BNSS adapts to modern challenges by allowing trials involving electronic communication to be conducted in courts where the communication was sent or received, Section 173. For example, in a case of online fraud initiated from Bangalore but affecting a victim in Hyderabad, the Hyderabad court could have jurisdiction if the victim received the fraudulent communication there. Special cases, dacoity and other offenses. Section 201 specifically addresses offenses like dacoity or belonging to a gang of dacoits, allowing trials in any district where the offense was committed or the accused was found. This provision ensures flexibility in serious cases involving organized crime. Transfer of cases. Section 211 allows the accused to apply for a transfer of the case to another court if they believe a fair trial is not possible in the original jurisdiction. The High Court or Sessions Court may approve such transfers to ensure justice. For example, in high-profile cases attracting significant media attention, a transfer may be sought to avoid prejudice. Consider a case where a cybercrime involving phishing emails originates in Pune but targets victims across India. Under Section 173, a victim in Lucknow could file an FIR, and the local court in Lucknow could try the case, even though the offense was initiated elsewhere. This flexibility ensures accessibility for victims in digital crimes. Landmark case, D.K. Basu v. State of West Bengal. The case of D.K. Basu v. State of West Bengal, Air 1997 SC 610, is a seminal judgment that underscores the importance of procedural safeguards in criminal trials, including jurisdiction and fair trial principles. While primarily focused on arrest and detention, The case highlights the judiciary's role in ensuring that trials adhere to constitutional and statutory mandates, including proper jurisdictional adherence. In 1986, D.K. Basu, Executive Chairman of Legal Aid Services, West Bengal, wrote to the Supreme Court highlighting custodial violence and deaths in police lock UPS. The petition sought guidelines to prevent arbitrary arrests and ensure fair treatment during investigations and trials. The Supreme Court treated the letter as a public interest litigation, PIL, and examined the procedural framework under the CrPC, now succeeded by the BNSS. One of the issues was whether arrests and subsequent trials complied with jurisdictional requirements under the CrPC, now BNSS. The court noted that improper arrests, often outside the jurisdiction of the arresting authority, undermine the trial process. For instance, detaining an accused without presenting them before the nearest magistrate within 24 hours, Section 58, BNSS, violated procedural norms and could affect the trial's validity. The Supreme Court issued 11 guidelines to safeguard the rights of the accused, including, 22. The police must produce the accused before the nearest magistrate within 24 hours, irrespective of jurisdiction, Section 58, BNSS. Arrest memos must specify the place of arrest, ensuring jurisdictional transparency. The accused has the right to be informed of the grounds of arrest, facilitating a fair trial in the appropriate court. These guidelines reinforce the BNSS's jurisdictional principle by ensuring that arrests and investigations occur within the legal framework, enabling trials to proceed in the correct jurisdiction. Under the BNSS, Section 58 mirrors the CrPC's provision, requiring that an arrested person be produced before the nearest magistrate, whether or not they have jurisdiction, within 24 hours. This ensures that jurisdictional errors during arrest do not prejudice the trial. The D.K. Basu case remains relevant, as it emphasizes the judiciary's role in upholding procedural integrity, including the correct application of Section 199. Critical analysis. The BNSS's adherence to the principle of local jurisdiction reflects a balance between procedural efficiency and fairness. By anchoring trials to the place of the offense, the BNSS minimizes logistical challenges and ensures community involvement. However, the exceptions in Sections 200-206 demonstrate the legislature's recognition of modern complexities, such as cross-jurisdictional crimes and cybercrimes. These provisions enhance access to justice but raise challenges, such as potential forum shopping, where parties may choose jurisdictions perceived as favorable. The lack of codified sentencing guidelines in the BNSS, as noted in legal commentary, could lead to inconsistencies in trials across jurisdictions. For instance, a magistrate in one district may impose a harsher sentence than another for the same offense, undermining uniformity. Incorporating sentencing guidelines, as seen in jurisdictions like the UK, could enhance fairness. Additionally, the BNSS's reliance on electronic trials, Section 530, requires robust infrastructure to prevent disparities in access to justice, particularly in rural areas. The D.K. Basu case illustrates the judiciary's critical role in scrutinizing procedural compliance. Future cases under the BNSS will likely test its provisions, particularly in cybercrime and cross-jurisdictional scenarios. Courts must ensure that exceptions to Section 199 do not dilute the accused's right to a fair trial under Article 21 of the Constitution. 23. Question 6. Anticipatory bail. What do you understand by anticipatory bail? When is it accepted? Explain the differences between ordinary bail and anticipatory bail. Understanding anticipatory bail. Anticipatory bail, governed by Section 482 of the BNSS, equivalent to Section 438 of the CrPC, is a pre-arrest legal remedy that allows a person apprehending arrest for a non-bailable offense to seek bail from a competent court. Unlike ordinary bail, which is sought after arrest, anticipatory bail is a proactive measure to prevent detention. Upon granting anticipatory bail, the court directs that, in the event of arrest, the applicant be released on bail subject to specified conditions. This provision balances the right to personal liberty under Article 21 of the Constitution with the state's interest in ensuring justice. Anticipatory bail applies only to non-bailable offenses, as defined under Section 2(m) of the BNSS, where bail is not a matter of right and is subject to judicial discretion. Examples include serious offenses like murder, Section 103, Bhartiya Nagarik Sanhita, 2023 BNS, rape, Section 64, BNS, or cheating, Section 318, BNS. For instance, if an individual fears arrest due to a false accusation of cheating, they may approach the Sessions Court or High Court under Section 482 to seek anticipatory bail, ensuring protection from immediate detention. The concept of anticipatory bail was introduced in the CrPC, 1973, following recommendations of the 41st Law Commission Report, 1969, which recognized the need to protect individuals from harassment through unfounded allegations. The BNSS retains this provision with minor modifications, such as allowing electronic filing of bail applications and mandating timelines for disposal, reflecting its commitment to technological integration and expeditious justice. Conditions for acceptance of anticipatory bail under Section 482, 1. A person who has reason to believe they may be arrested for a non-bailable offense can apply to the High Court or Court of Session for anticipatory bail. The court considers several factors before granting relief, including the nature and gravity of the offense, the applicant's antecedents, the likelihood of absconding, and the potential for tampering with evidence or influencing witnesses. The BNSS does not prescribe a rigid formula, granting courts wide discretion to ensure justice. The Supreme Court has established comprehensive guidelines for anticipatory bail, which the BNSS implicitly incorporates. In Gurbakshir Singh Sibia v. State of Punjab, 1980, a constitution bench outlined key principles. Anticipatory bail is not limited to exceptional cases but can be granted where arrest is unwarranted or motivated by mala fide intent. Courts must balance individual liberty with the investigation's integrity, considering factors like the offense's severity and the applicant's cooperation. 24 conditions such as regular reporting to police or surrendering passports may be imposed to prevent misuse. For example, in a case where a corporate executive fears arrest in a fraud case, Section 318, BNS, due to a rival's false complaint, the court may grant anticipatory bail if the executive demonstrates cooperation and no prior criminal record. The BNSS introduces procedural enhancements. Section 482, 2, mandates that the public prosecutor be heard before granting anticipatory bail, ensuring the state's perspective is considered. Additionally, Section 482, 3, allows courts to impose conditions, such as prohibiting the applicant from leaving India without permission or requiring them to join the investigation. For instance, in a hypothetical dowry harassment case, Section 85, BNS, the court may grant anticipatory bail to the accused, a non-resident Indian, with a condition to surrender their passport. Anticipatory bail is rarely granted in cases involving heinous offenses like terrorism, Section 111, BNS, or offenses under special laws like the Unlawful Activities Prevention Act, 1967, where stringent bail conditions apply. In Sidaram Sadlingapam Hetra v. State of Maharashtra, 2011, the Supreme Court emphasized that anticipatory bail should not be a blanket protection but a reasoned relief, considering the case's facts. The BNSS aligns with this by requiring courts to record reasons for granting or rejecting bail, enhancing transparency. The landmark case of Sushala Agarwal v. State, NCT, of Delhi, 2020, clarified several aspects of anticipatory bail, holding that anticipatory bail need not be limited in duration unless exceptional circumstances, like non-cooperation, justify it. Courts should not impose arbitrary conditions unrelated to the case's needs. This ruling ensures that anticipatory bail under the BNSS remains a flexible remedy, adaptable to case-specific requirements. For example, in a case of alleged criminal breach of trust, Section 316, BNS, the court may grant anticipatory bail without a time limit if the accused poses no flight risk. Differences between ordinary bail and anticipatory bail. Ordinary bail, governed by Sections 479 and 480 of the BNSS, is sought after an accused is arrested or detained. Section 479 applies to bailable offenses, where bail is a right, such as simple hurt, Section 331, BNS. Section 480 pertains to non-bailable offenses, where bail is discretionary, based on factors like evidence strength and the accused conduct. Ordinary bail is reactive, addressing an existing deprivation of liberty, whereas anticipatory bail is proactive, preventing such deprivation. The differences between ordinary bail and anticipatory bail can be analyzed across several dimensions. One stage of application: anticipatory bail, sought before arrest, when the applicant apprehends detention based on reasonable grounds, such as a registered FIR or credible threat. For instance, in a case of 25 alleged extortion, Section 308, BNS, a journalist may seek anticipatory bail upon learning of a politically motivated FIR. Ordinary bail, applied for after arrest or detention, typically at the police station, for bailable offenses, or court, for non-bailable offenses. For example, an accused arrested for robbery, Section 310, BNS, applies for ordinary bail post-arrest. Two legal provisions: anticipatory bail, governed by Section 482, applicable only to non-bailable offenses and available only at the Sessions Court or High Court. The BNSS retains the CrPC's framework, with added procedural safeguards like mandatory prosecutor hearings. Ordinary bail, governed by Sections 479, bailable offenses, and 480, non-bailable offenses, applicable at various stages and courts, including magistrate courts, depending on the offense's severity. 3. Nature of relief: anticipatory bail provides conditional protection against arrest. If arrested, the applicant is released immediately upon fulfilling bail conditions, such as furnishing a bond. In Arnish Kumar v. State of Bihar, 2014, the Supreme Court emphasized that anticipatory bail prevents unnecessary arrests, particularly in offenses punishable with less than 7 years imprisonment. Ordinary bail secures release from custody after arrest. The court or police assess the case's merits post-detention, as seen in State of Rajasthan v. Balkand, 1977, where the court prioritized bail over jail for non-bailable offenses unless compelling reasons exist. For conditions imposed: anticipatory bail, courts impose stringent conditions to ensure cooperation, such as regular police reporting or restrictions on influencing witnesses, as per Section 482(3). For example, in a case of alleged criminal conspiracy, Section 342, BNS, the court may require the accused to join the investigation. Ordinary bail, conditions vary but are generally less restrictive for bailable offenses. For non-bailable offenses, conditions may be imposed, but the focus is on post-arrest circumstances, such as the accused behavior in custody. 5. Judicial discretion: anticipatory bail, courts exercise broader discretion due to the absence of custodial interrogation at the application stage. In Bhadresh Bipin Bhai Sheth v. State of Gujarat, 2016, the Supreme Court held that anticipatory bail decisions must consider the applicant's apprehension and the investigation's needs. 26. Ordinary bail, * judicial discretion is guided by post-arrest evidence and circumstances. For instance, in a murder case, Section 103, BNS, the court evaluates the prosecution's strength before granting ordinary bail, as per Section 480. The distinction ensures that anticipatory bail protects against pre-arrest harassment, while ordinary bail addresses post-arrest detention. The BNSS enhances both mechanisms by streamlining applications through electronic means and enforcing timelines for bail hearings, reducing delays. However, challenges like judicial backlog and inconsistent application of bail guidelines persist, necessitating uniform implementation. Leading case law illustration: the case of Gurbakshir Singh Sibia v. State of Punjab, 1980, is foundational for anticipatory bail. The accused, a minister, feared arrest in multiple cases due to political vendettas. The Supreme Court granted anticipatory bail, holding that the provision under Section 438, now Section 482 of BNSS, is a tool to prevent misuse of arrest powers. The court rejected the contention that anticipatory bail should be limited to exceptional cases, emphasizing its role in protecting liberty. This ruling guides BNSS application, ensuring that courts exercise discretion judiciously. Another significant case, Savita v. State of Delhi, 2005, illustrates the difference in application. The accused sought anticipatory bail in a dowry death case, Section 103(2) BNS, but the court denied it due to the offense's gravity and prima facie evidence. However, post-arrest, the accused was granted ordinary bail after custodial interrogation revealed weak evidence, highlighting the distinct stages and considerations for each bail type. 27. Question 7. Judgment and appeal. What is judgment? Can an appeal be made against a judgment? If yes, explain it. Understanding the concept of a judgment under the BNSS is the final pronouncement by a court in a criminal trial, determining the guilt or innocence of the accused and specifying the punishment, if any, or other orders. It is the culmination of the trial process, reflecting the court's application of law to the facts established through evidence. Section 394 of the BNSS defines a judgment as a statement delivered by the presiding judge, either in open court or through written form, containing the points for determination, the decision, and the reasons thereof. The judgment must be clear, reasoned, and compliant with procedural and constitutional mandates to ensure fairness. The purpose of a judgment is threefold: 1. To deliver justice by resolving the dispute; 2. To provide a reasoned basis for the decision to ensure transparency; and 3. To enable appellate review by articulating the legal and factual grounds. A judgment must comply with the principles of natural justice, including the right to a fair hearing and an impartial decision, as guaranteed under Article 21. Example: in a case of murder under Section 103 of the Bhartiya Nagarik Sanhita, 2023, BNS, the judgment would state whether the accused is guilty, the evidence supporting the finding, and the sentence, e.g., life imprisonment or acquittal, along with detailed reasons. Case law: in Surendra Singh v. State of Uttar Pradesh, 1954, SCR 330, the Supreme Court emphasized that a judgment must contain a clear statement of findings and reasons to enable appellate review, a principle codified in Section 394 of the BNSS. Contents of a judgment under the BNSS. Section 394 of the BNSS outlines the essential components of a judgment, ensuring it is comprehensive and transparent. The contents are designed to provide clarity to the parties involved and facilitate appellate scrutiny. The key elements include: 1. Points for determination. The judgment must identify the specific issues or points for determination, such as whether the accused committed the alleged offense and whether the prosecution proved its case beyond reasonable doubt. Example: in a theft case under Section 303 BNS, the judgment might list points such as: 1. Did the accused take the property? 2. Was the taking without consent? 3. Was there dishonest intent? 2. Decision on each point. The court must provide a clear decision on each point, stating whether the prosecution's allegations are substantiated by evidence. This ensures that the judgment addresses all relevant issues. 28. Example: in the theft case, the court may find that the accused took a mobile phone without consent, with evidence of CCTV footage proving dishonest intent, leading to a guilty verdict. 3 reasons for the decision. The judgment must include detailed reasons for the court's findings, referencing the evidence, witness testimonies, and legal provisions. This ensures transparency and compliance with Article 21. Example, the judgment might state, the prosecution proved beyond reasonable doubt that the accused committed theft, as corroborated by the victim's testimony and CCTV evidence, satisfying the elements of Section 303 BNS. For pronouncement of sentence or order, if the accused is found guilty, the judgment must specify the sentence, such as imprisonment, fine, or both, in accordance with the BNS or other penal laws. If acquitted, the judgment must order the release of the accused, subject to any pending matters. Example, for a conviction under Section 316 BNS, cheating, the judgment may impose a sentence of 3 years imprisonment and a fine of Rs 10,000. 5. Language and delivery. Section 394, 1, mandates that the judgment be written in the language of the court, e.g., English or the regional language, and pronounced in open court. If not delivered immediately, it must be pronounced within 30 days of the conclusion of the trial, extendable to 45 days with reasons recorded. Section 394, 3. Case law, in Balraj v. State of Uttar Pradesh, 1993, 1 SCC 369, the Supreme Court held that a judgment must be reasoned and delivered promptly to uphold fairness, a principle reflected in the BNSS timelines. 6 additional requirements. The BNSS introduces modern requirements, such as providing a copy of the judgment to the accused and the prosecution free of cost. Section 394, 4. For serious offenses, the judgment may be recorded using audio-video means to enhance transparency. Can an appeal be made against a judgment? Yes, an appeal can be made against a judgment under the BNSS, as the right to appeal is a fundamental safeguard in the criminal justice system, ensuring that erroneous decisions can be reviewed and corrected by higher courts. The BNSS provides a structured framework for appeals under Chapter XXX, Sections 435 to 458, which corresponds to Chapter XXIX of the CrPC but includes enhancements for efficiency and accessibility. The right to appeal is both statutory and 29 constitutional, rooted in the principles of fairness and due process under Articles 14 and 21 of the Constitution. Nature of the right to appeal. The right to appeal is not an inherent right but a statutory one, conferred by the BNSS. However, once granted, it becomes integral to the right to a fair trial. In M.H. Hoskot v. State of Maharashtra, 1978, 3 SCC 544, the Supreme Court held that the right to appeal is a facet of Article 21, ensuring access to justice through appellate review. Provisions governing appeals under the BNSS. The BNSS categorizes appeals based on the court delivering the judgment, the nature of the offense, and the sentence imposed. The key provisions are, Section 435, provides for appeals from convictions by a high court in its original jurisdiction to a bench of 2 or more judges of the same court. Section 436, governs appeals from convictions by sessions courts or additional sessions courts to the High Court. Section 437, allows appeals from orders of magistrates to the Sessions Court. Section 438, specifies that no appeal lies in petty cases, such as those with a sentence of a fine not exceeding Rs 1,000 or imprisonment not exceeding 3 months, unless the sentence is illegal. Section 440, permits appeals against acquittals by the prosecution, subject to leave of the High Court. Section 441, allows appeals against sentences on grounds of inadequacy, typically by the state. Example, if a Sessions Court convicts an accused under Section 103 BNS for murder and imposes life imprisonment, the accused can appeal to the High Court under Section 436 BNSS, challenging the conviction or sentence. Who can appeal? The BNSS specifies the parties eligible to file an appeal. Convicted person. An accused person convicted by a trial court can appeal against the conviction or sentence, Section 436. Prosecution/state, the state or central government can appeal against an acquittal, Section 440, or an inadequate sentence, Section 441, subject to court approval. 30. Complainant/victim, Section 439 allows a complainant in a complaint case to appeal against an acquittal with the leave of the court. The BNSS also strengthens victim rights, allowing victims to appeal against acquittals in certain cases. Example, in a rape case under Section 64 BNS, if the accused is acquitted, the victim may seek leave to appeal under Section 439 BNSS, citing insufficient evidence evaluation. Grounds for appeal. Appeals can be filed on various grounds, including error of law, if the trial court misinterprets the law, such as applying an incorrect provision of the BNS. Error of fact, if the court's findings are not supported by evidence or are perverse. Procedural irregularities, if the trial violates BNSS procedures, such as improper framing of charges, Section 246. Miscarriage of justice, if the judgment causes prejudice to the accused or the prosecution. Case law, in State of Gujarat v. Mohanlal Jitamalji Porwal, 1987, 2 SCC 364, the Supreme Court allowed an appeal against acquittal due to the trial court's failure to appreciate evidence, emphasizing the appellate court's role in correcting errors. Procedure for filing an appeal. The BNSS outlines the procedural requirements for appeals. 1. Filing the appeal. Appeals must be filed within the period of limitation prescribed under the Limitation Act, 1963, typically 30 to 90 days, depending on the court and case type, Section 458 BNSS. 2. Leave of court. Appeals against acquittals or petty cases require the appellate court's leave, Sections 438 and 440. 3. Suspension of sentence. Under Section 432, the appellate court may suspend a sentence pending appeal and grant bail to the accused. 4. Hearing. The appellate court hears both parties, examines the trial record, and may take additional evidence under Section 435, 3, if necessary. Example, in a cheating case under Section 316 BNS, if the accused is convicted and sentenced to 2 years imprisonment, they may file an appeal under Section 437 to the Sessions Court seeking suspension of the sentence under Section 432. 31. Limitations on appeals. The BNSS imposes restrictions to prevent frivolous appeals, no appeal in petty cases, Section 438 billion Argentine pesos. Appeals in cases with minor sentences unless the sentence is illegal. No appeal in plea bargaining, Section 291, 10, prohibits appeals against convictions based on plea bargaining, except on grounds of voluntariness. Limitations on acquittal appeals. Appeals against acquittals require high court leave and are limited to cases of manifest error or miscarriage of justice. Case law, in Tirath Singh v. State of Punjab, 1977, 3 SCC 216, the Supreme Court clarified that appellate courts should not interfere with acquittals unless the trial court's findings are perverse or unreasonable. Judicial safeguards in appeals. The BNSS and judicial precedents provide safeguards to ensure fair appellate review. Right to legal aid. In M.H. Hoskot v. State of Maharashtra, 1978, 3 SCC 544, the Supreme Court mandated free legal aid for indigent appellants, a principle incorporated into Section 341 BNSS. Reasoned decisions. Appellate courts must provide reasoned orders, as emphasized in Rambali v. State of Uttar Pradesh, 2004, 10 SCC 598. Protection against double jeopardy, Article 20, 2, and Section 336 BNSS prevent an accused from being tried twice for the same offense, limiting appeals against acquittals. Critical analysis. The BNSS enhances the framework for judgments and appeals by introducing modern elements, such as audio-video recording of proceedings and strict timelines for judgment delivery, Section 394, 3. These reforms promote transparency and efficiency. However, challenges remain, including delays in appellate courts due to backlog, which may undermine the right to speedy justice. The restriction on appeals in petty cases, Section 438, prevents frivolous litigation but may limit access to justice in borderline cases. The provision for victim appeals, Section 439, is a progressive step, aligning with global trends in victim-centric justice. However, the requirement for leave in acquittal appeals may deter victims, particularly in cases involving powerful accused. The Supreme Court's observations in K.S. Panduranga v. State of Karnataka, 2013, 3 SCC 721 highlight the need for appellate courts to balance deference to trial court findings with the duty to correct errors, a balance the BNSS seeks to achieve. 32 Question 8, Appeal and Powers of Appellate Court. What is appeal? Discuss the powers of the appellate court. Defining appeal under the BNSS. The BNSS does not explicitly define the term appeal, but its provisions, particularly sections 436-455, indicate that an appeal is a legal process by which a higher court reviews the decision of a lower court to correct errors in law, fact, or procedure. Unlike an inquiry or investigation, which focus on evidence collection and preliminary proceedings, an appeal involves a judicial re-examination of the trial court's findings, often limited to specific grounds such as misapplication of law, procedural irregularities, or perverse findings. Chapter XXXI of the BNSS outlines various types of appeals. Appeals from convictions, Section 436. An accused convicted by a magistrate or court of session may appeal to a higher court, such as the Sessions Court or High Court, respectively. Appeals against acquittals, Section 440. The state or complainant may appeal against an acquittal, subject to restrictions to prevent frivolous appeals. Appeals for enhancement of sentence, Section 441. The state may seek a harsher sentence if the trial court's sentence is deemed inadequate. Appeals in petty cases, Section 437. No appeal lies in cases of minor offenses where the punishment is a fine not exceeding 1,000, unless a question of law is involved. Consider a case where an accused is convicted of theft under Section 303 of the Bhartiya Nagarik Sanhita, 2023, BNS, by a judicial magistrate and sentenced to 1 year's imprisonment. If the accused believes the conviction was based on insufficient evidence, they may appeal to the Sessions Court under Section 436, seeking a re-evaluation of the evidence or quashing of the conviction. Nature and scope of appeals. Appeals under the BNSS are distinct from revisions, Sections 456-462, which involve supervisory jurisdiction to correct jurisdictional errors or illegality, and reviews, which are limited to errors apparent on the record. Appeals are a statutory right, subject to limitations prescribed by the BNSS. For instance, Section 437 restricts appeals in petty cases to prevent overburdening appellate courts, reflecting the BNSS's emphasis on judicial efficiency. The grounds for appeal typically include, 1. Error of law, misinterpretation of provisions, such as applying the wrong section of the BNS. 2. Error of fact, misappreciation of evidence, such as ignoring key witness testimony. 3. Procedural irregularities, failure to follow BNSS procedures, such as denying the accused the right to cross-examine witnesses, Section 273. 33.4. Miscarriage of justice, when the trial court's decision is perverse or unsupported by evidence. Suppose a magistrate convicts an accused of criminal breach of trust, Section 314, BNS, without allowing the defense to present crucial documentary evidence. The accused may appeal under Section 436, arguing that the denial of their right to a fair trial under Section 273 constitutes a procedural irregularity warranting reversal. Powers of the Appellate Court. The BNSS grants appellate courts broad powers to ensure justice, as detailed in Section 442, which mirrors Section 386 of the CrPC. These powers include, 1. Reversing or altering findings, the appellate court may reverse a conviction or acquittal or alter the findings, such as changing a conviction from murder, Section 103, BNS, to culpable homicide, Section 100, BNS. 2. Modifying sentences, the court may enhance, reduce, or alter the nature of the sentence, such as commuting a death sentence to life imprisonment. 3. Ordering a retrial, if the trial court's proceedings are vitiated by serious irregularities, the appellate court may order a fresh trial. 4. Dismissing appeals, the court may dismiss frivolous or meritless appeals summarily under Section 438. 5. Taking additional evidence, under Section 442, 2, the appellate court may take additional evidence or direct the trial court to do so if it is necessary for justice. 6. Suspending sentence or granting bail, Section 440 allows the appellate court to suspend a sentence or grant bail pending the appeal's disposal. The appellate court's powers are not merely supervisory but involve a substantive re-examination of the case. However, the BNSS balances this authority with restrictions to prevent abuse. For instance, Section 440, 3, requires leave of the High Court for appeals against acquittals, ensuring that only meritorious cases proceed. In a case of grievous hurt, Section 117, BNS, if the trial court imposes a lenient sentence of 1 year's imprisonment despite evidence of severe injury, the state may appeal under Section 441 for enhancement. The appellate court, after reviewing medical evidence, may enhance the sentence to 5 years, exercising its power under Section 442. Procedure for appeals. The BNSS prescribes a structured procedure for appeals. Filing the appeal. Appeals must be filed within the limitation period, typically 30-60 days, as per Section 436, 2, in the appropriate court, such as the Sessions Court for Magistrates' decisions or the High Court for Sessions Court decisions. 30. For presentation of grounds, the appellant must clearly state the grounds of appeal, supported by the trial court's record, Section 439. 3. Summary dismissal. Under Section 438, the appellate court may dismiss an appeal summarily if it lacks merit, without a full hearing. Hearing and judgment. If admitted, the appeal is heard, with both parties presenting arguments. The court delivers a reasoned judgment, exercising its powers under Section 442. Suppose an accused is acquitted of cheating, Section 316, BNS, by a magistrate. The complainant files an appeal under Section 440 in the Sessions Court alleging that the acquittal ignored documentary evidence of fraud. The court admits the appeal, hears both parties, and may reverse the acquittal if the evidence warrants it. Landmark case, State of Maharashtra v. Sujay Manjpoyarkar. The case of State of Maharashtra v. Sujay Manjpoyarkar, 2008, 9 SCC 177 is a landmark judgment that elucidates the appellate court's powers, particularly in appeals against acquittals. The case involved the acquittal of the accused for murder under Section 302 of the Indian Penal Code, 1860, now Section 103, BNS, by the trial court, prompting the state to appeal to the High Court. The accused, Sujay Poyarkar, was charged with murdering his wife by setting her on fire. The trial court acquitted him, citing inconsistencies in witness testimonies and lack of conclusive evidence. The state appealed to the Bombay High Court, which reversed the acquittal, convicting the accused based on a reappreciation of evidence, including dying declarations and circumstantial evidence. The accused appealed to the Supreme Court, challenging the High Court's interference with the acquittal. The primary issue was the extent to which an appellate court can interfere with an acquittal under Section 378 of the CrPC, now Section 440, BNSS. The Supreme Court examined whether the High Court's reversal was justified or constituted an overreach of appellate powers. The Supreme Court upheld the High Court's decision, laying down key principles governing appellate powers. An appellate court can reverse an acquittal if the trial court's findings are perverse, unreasonable, or unsupported by evidence. The court must reappraise the entire evidence but should not lightly interfere with an acquittal, given the presumption of innocence. If two reasonable views are possible, the appellate court should defer to the trial court's view unless it is manifestly erroneous. In this case, the Supreme Court found that the trial court ignored the dying declaration, which was corroborated by medical evidence, rendering the acquittal perverse. The High Court's reversal was thus upheld, emphasizing the appellate court's duty to correct miscarriages of justice. 35 Under the BNSS, Section 440 mirrors the CrPC's provisions, requiring leave for appeals against acquittals to filter out frivolous cases. The Poyarker case remains relevant, as it clarifies the appellate court's power to re-evaluate evidence under Section 442 while respecting the trial court's findings unless they are patently wrong. Critical analysis. The BNSS's appellate framework balances the right to appeal with judicial efficiency. By restricting appeals in petty cases, Section 437, and requiring leave for acquittals, Section 440, the BNSS prevents clogging of higher courts while ensuring access to justice in serious cases. The broad powers under Section 442 empower appellate courts to correct errors comprehensively, from reversing convictions to ordering retrials, aligning with Article 21's guarantee of a fair trial. However, challenges persist: delay in disposal. Appellate courts, particularly high courts, face backlogs, delaying justice. The BNSS's emphasis on electronic hearings, Section 530, could mitigate this, but infrastructure gaps remain. Subjectivity in evidence reappreciation. The Poyarker case highlights the risk of appellate courts substituting their view for the trial courts, potentially undermining the trial process. Clear guidelines on perversity could enhance consistency. Access to justice. The requirement of leave for acquittal appeals may deter genuine appellants, particularly victims without legal resources. To address these challenges, the BNSS could: 1. Introduce time-bound appeal disposal mechanisms, as suggested by the 239th Law Commission Report, 2012. 2. Provide clearer criteria for perverse findings to guide appellate courts, drawing from precedents like Poyarker. 3. Enhance legal aid for appellants, aligning with Section 341, to ensure equitable access to appellate remedies. 36. Question 9. Maintenance under Section 125 Criminal Procedure Code. Who can claim maintenance under Section 125 Criminal Procedure Code? Explain. Overview of maintenance under Section 144. BNSS. Maintenance under Section 144 of the BNSS is a statutory obligation imposed on a person with sufficient means to provide financial support to specific dependents who are unable to maintain themselves. The provision aims to prevent destitution and vagrancy, aligning with the constitutional mandate of social justice under Articles 15, 3, and 39 of the Constitution of India. It is a secular and summary remedy, applicable irrespective of religion, and enforceable through criminal courts to ensure swift relief. Section 144 of the BNSS mirrors Section 125 of the CrPC with minor procedural enhancements, such as the option for electronic filing of applications and stricter timelines for disposal to reduce delays. The provision is quasi-civil in nature, focusing on financial support rather than criminal punishment, and is enforced through magistrates to ensure accessibility. Persons entitled to claim maintenance under Section 144, 1, of the BNSS. The following categories of persons can claim maintenance from an individual with sufficient means who neglects or refuses to maintain them. 1. Wife. A legally wedded wife unable to maintain herself can claim maintenance from her husband. The term wife includes a woman whose marriage is valid under applicable personal laws or, in certain cases, under customary law. 2. Legitimate or illegitimate minor child. A minor child, below 18 years, whether legitimate or illegitimate, who is unable to maintain themselves, is entitled to maintenance from their father or mother. 3. Legitimate or illegitimate child, not minor, with disability. A child, whether legitimate or illegitimate, who has attained majority but is unable to maintain themselves due to physical or mental abnormality or injury, can claim maintenance. 4 parents, a father or mother unable to maintain themselves can claim maintenance from their son or daughter. 1 wife, a wife can claim maintenance if she is unable to support herself and the husband has neglected or refused to provide for her. The BNSS does not define wife explicitly, but judicial interpretations clarify that it includes only a legally wedded wife under applicable personal laws. For example, a Hindu wife married under the Hindu Marriage Act, 1955, or a Muslim wife under Sharia law can claim maintenance. However, a woman in a live-in relationship does not qualify as a wife unless the relationship is deemed a relationship in the nature of marriage under specific circumstances. 37 In Shanmuni Yabi Virendra Kumar Singh Kushwaha, 2011, the Supreme Court held that a woman in a long-term live-in relationship, resembling marriage, may claim maintenance under Section 125 of the CrPC, now Section 144, BNSS, provided the relationship meets criteria like cohabitation and mutual intent. For instance, if a woman lives with a man for several years, presenting themselves as a married couple, she may claim maintenance if deserted, even without a formal marriage. However, a wife living in adultery or who has deserted the husband without sufficient cause may be denied maintenance under Section 144(3). For example, in a hypothetical case, if a wife leaves her husband due to domestic violence, she remains eligible, but if she leaves voluntarily to live with another person, her claim may be rejected. 2 Minor child, legitimate or illegitimate, a minor child, whether born within or outside wedlock, can claim maintenance from their father or mother if unable to maintain themselves. The BNSS emphasizes the child's welfare, irrespective of the parent's marital status. For instance, an illegitimate child born to a couple in a live-in relationship can claim maintenance from the father if he neglects his duty. In Savitaban Somabai Bhartiya v. State of Gujarat, 2005, the Supreme Court upheld the right of an illegitimate child to maintenance under Section 125 of the CrPC, emphasizing that the child's legitimacy does not affect their entitlement. Under the BNSS, this principle continues, ensuring that a minor child, say, abandoned by a father earning a substantial income, can secure maintenance for education and sustenance. 3 Child with disability, not minor, a major child, above 18 years, who is unable to maintain themselves due to physical or mental disability or injury is entitled to maintenance. This provision recognizes the ongoing dependency of such children. For example, a 20-year-old daughter with a severe physical disability, unable to work, can claim maintenance from her parents under Section 144(1)(c). The case of Jagbir Singh v. State of Punjab, 1992, clarified that the disability must be substantial, preventing self-support. In a hypothetical scenario, a son with a mental disorder, unable to earn a living, can claim maintenance from his mother if she has sufficient means, even if he is an adult. 4 parents, whether father or mother, unable to maintain themselves, can claim maintenance from their son or daughter. This provision reflects the Indian ethos of filial duty and addresses the vulnerability of elderly parents. For instance, an aged mother, abandoned by her children and without income, can seek maintenance from her employed daughter. In Kirtikant D. Vadodara v. State of Gujarat, 1996, the Supreme Court held that a stepmother is not entitled to maintenance under Section 125 of the CrPC unless she is wholly dependent and has no other means. Under the BNSS, this interpretation applies, requiring proof of dependency 38 and neglect. For example, an elderly father with no pension can claim maintenance from his son, a government employee, if the son refuses to support him. Conditions for claiming maintenance. To claim maintenance under Section 144, the claimant must satisfy the following conditions: inability to maintain themselves, the claimant must demonstrate that they lack sufficient means to support themselves. This includes lack of income, property, or other resources, as seen in Rajathi v. C. Ganesan, 1999, where a wife with no income was granted maintenance. Neglect or refusal: the person liable, husband, parent, or child, must have neglected or refused to provide maintenance despite having sufficient means. For instance, a husband earning a substantial salary who fails to support his unemployed wife is liable. Sufficient means: the person from whom maintenance is sought must have adequate financial capacity. In Chaturbhuj v. Sidhabai, 2008, the Supreme Court clarified that sufficient means includes earning capacity, not just actual income. The application for maintenance is filed before a judicial magistrate of the first class under Section 144(1). The BNSS allows electronic filing, enhancing accessibility. The magistrate assesses the claim based on evidence, such as income documents or affidavits, and may grant interim maintenance under Section 144(8), to provide immediate relief. For example, a wife seeking maintenance can file an application online, and the court may order interim maintenance pending the final hearing. The BNSS imposes a 60-day timeline for disposing of maintenance applications, subject to reasonable extensions, to ensure swift justice. The maintenance amount is determined based on the claimant's needs, the respondent's income, and other factors like the standard of living, as per Section 144(5). Leading case law: several Supreme Court decisions have shaped the jurisprudence of maintenance, guiding its application under the BNSS. Bhagwan Dutt v. Kamla Devi, 1975. The court held that a wife's independent income does not automatically disqualify her from maintenance if it is insufficient for her needs. This principle ensures that a wife with minimal earnings can still claim support. Shamima Farooqi v. Shahid Khan, 2015. The court emphasized that maintenance is a right, not charity, and must enable the claimant to live with dignity, considering the husband's financial capacity. Rajanch v. Neha, 2020. A landmark ruling that standardized maintenance procedures, mandating affidavits of income and assets, interim maintenance, and time-bound disposal. The BNSS incorporates these guidelines, enhancing procedural fairness. 39. Consider a scenario where a divorced Muslim wife, unable to support herself, seeks maintenance from her ex-husband, a businessman. Under Section 144, she is entitled to maintenance until remarriage, as clarified in Daniel Latify v. Union of India, 2001, which upheld the constitutionality of maintenance for Muslim women under Section 125 of the CrPC, now applicable under the BNSS. If the husband refuses to pay, the magistrate can enforce payment through attachment of property or imprisonment under Section 144(7). Procedural innovations under BNSS. The BNSS introduces several reforms to streamline maintenance proceedings. Electronic filing: applications can be filed online, reducing barriers for claimants, especially in rural areas. Time-bound disposal: the 60-day timeline for adjudication minimizes delays, addressing the backlog issue highlighted in Rajanch v. Neha. Interim maintenance: Section 144(8), ensures immediate relief, preventing destitution during litigation. However, challenges like inconsistent judicial interpretations and enforcement issues persist, requiring robust implementation to realize the BNSS's objectives. 40. Question 10. Short notes on plea bargaining and transfer of criminal cases. Write a short note on a. Plea bargaining, b. Transfer of criminal cases. The BNSS recognizes three types of plea bargaining: 1. Sentence bargaining: the accused pleads guilty for a reduced sentence. 2. Charge bargaining: the accused pleads guilty to a lesser offense. 3. Fact bargaining: the accused admits to certain facts, limiting the prosecution's burden. Procedure for plea bargaining. The procedure under Sections 291-303 is structured to ensure voluntariness and fairness. 1. Application: the accused files an application for plea bargaining in the court where the trial is pending, Section 291. 2. Court's inquiry: the court verifies that the application is voluntary and not coerced, Section 292. A private hearing ensures the accused free consent. 3. Negotiation. The court facilitates discussions among the accused, prosecutor, complainant, and victim, if any, to reach a mutually satisfactory disposition. Section 293. 4. Agreement. If an agreement is reached, it is recorded, specifying the concessions, e.g., reduced sentence or charge. The court may reject the agreement if it finds it unjust. Section 294. 5. Judgment. The court delivers a judgment based on the agreement, which is final and non-appealable except on grounds of involuntariness. Section 295. Consider a case of criminal breach of trust. Section 314, BNS, punishable with up to 7 years imprisonment. The accused, a bank employee who misappropriated 500,000, files a plea bargaining application. After negotiations, the accused agrees to plead guilty, repay the amount, and serve a 1-year sentence instead of the maximum. The court, finding the agreement voluntary and fair, convicts the accused accordingly, saving judicial time and resources. Advantages and challenges. Plea bargaining offers several advantages: expeditious justice, reduces trial duration, addressing judicial backlog. Victim's interest, ensures compensation or restitution, as seen in Section 293, 4. 41. Prison decongestion, shorter sentences reduce overcrowding. However, challenges include coercion risks. Accused persons, especially those with limited legal aid, may feel pressured to plead guilty. Limited scope, exclusion of heinous crimes restricts its applicability. Judicial oversight, courts must rigorously ensure voluntariness to prevent abuse. Judicial perspective, Gian Singh v. State of Punjab. The case of Gian Singh v. State of Punjab, 2012, 10 SCC 303, while primarily addressing the quashing of FERs under Section 482 of the CrPC, now Section 528, BNSS, provides insights into plea bargaining's role in compounding offenses. The case involved a dispute under Section 307 of the Indian Penal Code, 1860, now Section 109, BNS, where the parties sought to settle the matter amicably. The accused were charged with attempt to murder, but the parties reached a compromise. The Supreme Court examined whether such settlements could be equated with plea bargaining or justified quashing the FER. The court distinguished plea bargaining from compounding, noting that plea bargaining involves a guilty plea for concessions, while compounding extinguishes the case without a trial. The court emphasized that plea bargaining, as under Chapter XXIA of the CrPC, now Sections 29303, BNSS, is a structured process requiring judicial oversight to protect the accused rights. It cautioned against informal settlements bypassing statutory safeguards, reinforcing the need for transparency in plea bargaining. The case underscores the BNSS's requirement that plea agreements be voluntary and fair, with courts acting as gatekeepers. Transfer of criminal cases. The transfer of criminal cases, governed by Sections 447-452 of the BNSS, allows courts to move a case from one court to another to ensure a fair trial, convenience, or expeditious disposal. This mechanism upholds the principle of natural justice, ensuring that no party is prejudiced by bias, logistical barriers, or other impediments to justice. Grounds for transfer. Section 447 empowers the Supreme Court, High Courts, and Sessions Courts to transfer cases. Common grounds include bias or prejudice, if the trial court's impartiality is questioned, such as due to local influences or media pressure. Convenience of parties, when witnesses or parties face significant logistical challenges. Expeditious disposal, to address delays in overburdened courts. 42. Complex jurisdictional issues, when an offense spans multiple jurisdictions, Section 199-206. Procedure for transfer. The BNSS outlines a clear procedure: 1. Application. Any party, including the accused, complainant, or prosecution, may apply for transfer to the High Court or Sessions Court, Section 448. 2. Hearing, the court hears the parties and examines grounds, such as evidence of bias or inconvenience, Section 449. 3. Order, the court may transfer the case to another court of competent jurisdiction, ensuring continuity of proceedings, Section 450. 4. Supreme Court's power, under Section 447, the Supreme Court may transfer cases interstate or within a state for justice's sake. Suppose a high-profile murder trial in Delhi attracts intense media scrutiny, potentially influencing the trial court. The accused applies for transfer under Section 448, citing bias risks. The Delhi High Court, after verifying the grounds, transfers the case to a court in Gurgaon, ensuring an impartial trial. Powers of courts in transfer. The BNSS grants courts broad powers. Supreme Court may transfer cases across states or to itself, Section 447, 1. High Court may transfer cases within its jurisdiction or to another high court's jurisdiction, Section 447, 2. Sessions Court may transfer cases between subordinate courts, Section 447, 3. Courts may also stay proceedings pending transfer, Section 451, to prevent parallel litigation. Judicial perspective. Gian Singh v. State of Punjab. In Gian Singh v. State of Punjab, the Supreme Court also addressed transfer issues indirectly, as the case involved concerns about fair trial due to local pressures. The court's power under Section 406 of the CrPC, now Section 447, BNSS, to transfer cases was highlighted as a tool to ensure impartiality. The judgment emphasized that transfers are warranted when a fair trial is jeopardized, such as in cases of communal tensions or media trials. Under Section 447, the principles from Gian Singh remain relevant. The BNSS empowers courts to transfer cases proactively to protect the accused right to a fair trial under Article 21. For instance, in cases involving influential accused, transfer to a neutral jurisdiction prevents local biases, as seen in high-profile cases like the 2G scam trial, transferred from Delhi to a special court. 43 Advantages and challenges transfer of cases offers: fair trial, mitigates bias, ensuring impartial adjudication. Accessibility, reduces logistical barriers for parties. Flexibility, addresses jurisdictional complexities in modern crimes. Challenges include delays. Transfer applications may prolong proceedings. Discretionary power, subjective decisions on transfers risk inconsistency. Resource constraints, transferred cases may strain receiving courts. Critical analysis. Plea bargaining under the BNSS promotes judicial efficiency by reducing trial burdens, as seen in its structured process, Sections 293-03. However, its limited scope excludes heinous crimes, potentially limiting its impact on backlog reduction. The Gian Singh case underscores the need for robust judicial oversight to prevent coerced agreements, aligning with the BNSS's emphasis on voluntariness. The transfer mechanism, Sections 447-452, ensures fairness but requires clear criteria to prevent abuse. The Gian Singh judgment highlights the judiciary's role in safeguarding impartiality, a principle reinforced by the BNSS. However, delays in transfer decisions and resource disparities across courts pose challenges, necessitating infrastructural reforms. To enhance these mechanisms, 1. Expand plea bargaining scope to include certain non-heinous offenses with victim consent, as recommended by the 142nd Law Commission Report, 1991. 2. Introduce time-bound transfer disposal mechanisms to prevent delays. 3. Strengthen legal aid under Section 341 to support plea bargaining and transfer applications, ensuring access for indigent parties. 44 Paper, Criminal Procedure Code / Bhartiya Nagarik Suraksha Sanhita, Set 2, 45 Question 11, Distinctions between offences. Write short notes on the following. I. Distinguish between bailable and non-bailable offenses. 2. Distinguish between cognizable and non-cognizable offenses. I. Distinction between bailable and non-bailable offenses. The BNSS classifies offenses into bailable and non-bailable categories based on the right to bail and the degree of judicial discretion involved. According to Section 2, c. A bailable offense is one listed as bailable in the first schedule of the BNSS or made bailable by any other law, where the accused has an absolute right to bail. Examples include simple hurt, Section 331, Bhartiya Nagarik Sanhita, 2023 BNS, and criminal trespass, Section 351, BNS. Conversely, a non-bailable offense, as implied under Section 2(m), encompasses all other offenses where bail is not a right but subject to judicial discretion. Examples include murder, Section 103, BNS, and rape, Section 64, BNS. For bailable offenses, Section 479 mandates that the police or court must grant bail upon the accused furnishing a bail bond, with or without sureties. For instance, an individual arrested for public nuisance, Section 351, BNS, can secure bail from the police station by executing a bond. In contrast, Section 480 governs bail in non-bailable offenses, where courts consider factors such as the offense's severity, evidence strength, the accused criminal history, and the likelihood of absconding or tampering with evidence. For example, in a robbery case, Section 310, BNS, the court may grant bail only after evaluating the prosecution's case and the accused conduct. In bailable offenses, the process is straightforward, ensuring immediate release to prevent unnecessary detention. Section 479(1) allows the police to grant bail at the time of arrest, reducing judicial burden. For instance, a person accused of petty theft, Section 317, BNS, can be released by the police upon providing a surety. Non-bailable offenses require a formal bail application before a magistrate, sessions court, or high court, with the public prosecutor given an opportunity to oppose under Section 480, 2. The BNSS introduces electronic filing of bail applications, streamlining access, particularly in rural areas. The Supreme Court has shaped the application of bail provisions, influencing their interpretation under the BNSS. In Arnish Kumar v. State of Bihar, 2014, the court emphasized that arrests in offenses punishable with less than 7 years imprisonment, often bailable, should be exceptional, and bail should be granted promptly to prevent harassment. This ruling aligns with Section 479, reinforcing the right to bail in bailable offenses. For non-bailable offenses, Gurbakshir Singh Sibia v. State of Punjab, 1980, clarified that courts must balance individual liberty with societal interests when considering bail, a principle codified in Section 480. For example, in a case of alleged dowry death, Section 103, 2, BNS, the court may deny bail due to the offense's gravity and prima facie evidence. In State of Rajasthan v. Balkand, 1977, the Supreme Court established the principle that bail is the rule and jail is the exception for bailable offenses, a guideline retained under the BNSS. In a hypothetical scenario, an accused charged with voluntarily causing hurt, Section 331, BNS, 46 would be entitled to bail as a matter of right, while an accused in a murder case, Section 103, BNS, would face stringent scrutiny, as seen in Prahlad Singh Bhatti v. NCT of Delhi, 2001, where bail was denied due to the seriousness of the offense. The distinction between bailable and non-bailable offenses ensures that minor offenses result in minimal detention, preserving personal liberty, while serious offenses allow judicial oversight to protect public interest. The BNSS enhances this framework by mandating timely bail hearings and electronic processes, but challenges like judicial backlog and inconsistent bail practices require ongoing reforms. For instance, a person accused of bailable criminal trespass can secure quick release, whereas a terrorism suspect, Section 111, BNS, faces rigorous bail conditions, reflecting the offense's impact on society. To elucidate the distinction, consider the following: bailable offenses, right to bail under Section 479. Examples: simple hurt, public nuisance. Procedure: bail granted by police or court with minimal scrutiny. Case law: Arnish Kumar v. State of Bihar, 2014. Non-bailable offenses, bail at court's discretion under Section 480. Examples: murder, rape. Procedure: formal application, prosecutor's input, and judicial evaluation. Case law: Gurbakshir Singh Sibia v. State of Punjab, 1980. 2. Distinction between cognizable and non-cognizable offenses. The BNSS categorizes offenses into cognizable and non-cognizable to delineate police powers in investigation and arrest. Under Section 2, G, a cognizable offense is one where a police officer may arrest without a warrant and initiate an investigation without a magistrate's prior approval, as specified in the first schedule or other laws. These are typically serious offenses, such as murder, Section 103, BNS, rape, Section 64, BNS, and kidnapping, Section 137, BNS. In contrast, Section 2.0 defines a non-cognizable offense as one where a police officer cannot arrest or investigate without a magistrate's order, as per Section 174.2. Examples include defamation, Section 356, BNS, and simple hurt, Section 331, BNS. For cognizable offenses, Section 173.1 mandates that a police officer must register a first information report, FIR, upon receiving information, which can be oral or electronic, with a requirement to sign electronic FIRs within 3 days. Section 173.3 introduces a novel provision allowing a preliminary inquiry for offenses punishable with 3 to 7 years imprisonment to ascertain a prima facie case before FIR registration. For example, in a case of theft, Section 317, BNS, the police can arrest the accused and begin investigation immediately upon receiving a complaint. In non-cognizable offenses, Section 175.3 requires the complainant to approach a 47 magistrate for an investigation order if the police refuse to act. For instance, in a case of public nuisance, Section 351, BNS, the police cannot investigate without a magistrate's directive. The Supreme Court has provided clarity on these distinctions, influencing their application under the BNSS. In Lalita Kumari v. Government of Uttar Pradesh, 2014, the court held that registration of an FIR is mandatory for cognizable offenses upon receiving credible information, except in cases requiring preliminary inquiry. The BNSS codifies this exception under Section 173.3, but the provision has raised concerns about potential misuse, as it grants police discretion to delay FIRs in certain cases. For non-cognizable offenses, State of Haryana v. Bajan Lal, 1992, established guidelines, emphasizing that police must obtain magistrate approval before acting, safeguarding against arbitrary investigations. In Youth Bar Association of India v. Union of India, 2016, the Supreme Court mandated that FIRs for cognizable offences be uploaded online within 24 hours, a practice now supported by the BNSS's electronic filing provisions. For example, an FIR for robbery, Section 310, BNS, must be registered and accessible online, enhancing transparency. In contrast, CP Subhash v. Inspector of Police, Chennai, 2013, clarified that non-cognizable offences, like minor disputes over property, require a magistrate's order for investigation, preventing police overreach. The cognizable and non-cognizable distinction ensures swift action for serious crimes while protecting individuals from unnecessary police intervention in minor cases. For instance, a victim of kidnapping can expect immediate police action, whereas a complainant alleging defamation must seek judicial intervention. The BNSS's preliminary inquiry provision for certain cognizable offenses aims to filter frivolous complaints but risks delaying justice, necessitating judicial oversight to prevent abuse. To summarize the distinction, cognizable offenses, police can arrest and investigate without warrant under Section 173. Examples: murder, rape, kidnapping. Procedure: immediate for registration, with preliminary inquiry for certain cases. Case law: Lalita Kumari v. Government of Uttar Pradesh, 2014. Non-cognizable offenses, police require magistrate's order to act under Section 175. Examples: defamation, public nuisance. Procedure: complainant must approach magistrate for investigation order. Case law: State of Haryana v. Bajan Lal, 1992. Interrelation and broader implications. The distinctions between bailable/non-bailable and cognizable/non-cognizable offenses are interconnected, as many cognizable offenses are non-bailable due to their severity, e.g., murder, while non-cognizable offenses are often bailable, e.g., simple hurt. However, this is not absolute. 48. For instance, cheating, Section 318, BNS, is cognizable but bailable in certain cases. The BNSS aligns these classifications with its first schedule, ensuring clarity in application. The procedural reforms under the BNSS, such as electronic FIRS and bail applications, enhance accessibility and transparency. However, challenges persist, including potential misuse of preliminary inquiries in cognizable offenses and delays in bail hearings for non-bailable offenses. Judicial precedents like Arnish Kumar and Lalita Kumari guide the BNSS's implementation, emphasizing liberty and accountability. For example, a person accused of a bailable and non-cognizable offense like public nuisance benefits from quick bail and limited police intervention, while a murder suspect faces rigorous scrutiny and immediate police action, reflecting the system's balance. 49. Question 12. History and objects of CrPC. Explain in detail the history and objects of the Code of Criminal Procedure, 1973, or relevant corresponding provisions of BNSS, 2023. Historical evolution of the Code of Criminal Procedure. The CrPC, 1973, was not an isolated legislative effort but the culmination of a long history of procedural law development in India, shaped by colonial influences, post-independence reforms, and societal demands. Pre-colonial and early colonial period. Before British colonization, India lacked a uniform criminal procedure. Legal systems were fragmented, with regions governed by religious texts, local customs, and rulers' edicts. During the Mughal era, Islamic law, Mohammedan criminal law, predominated in many areas, while Hindu laws applied in others. WEB 17. The absence of a standardized procedure led to inconsistencies in justice delivery. The British East India Company's arrival marked a shift toward structured legal systems. After the 1857 rebellion, the British Crown assumed direct control, enacting the first criminal procedure code in 1861 WEB 5. This code, however, favored European subjects, granting them immunity from criminal courts except the High Court, reflecting colonial biases. Subsequent amendments in 1872, 1882, and 1898 aimed to ensure uniform application across British and Indian subjects, but the legacy of preferential treatment persisted. WEB 5. Post-independence reforms and the CrPC, 1973. Post-independence, India inherited the Criminal Procedure Code of 1898, which required significant revisions to align with the democratic principles of a sovereign nation. The First Law Commission's 14th report, 1958, provided critical recommendations for judicial administration reforms, followed by the 41st Report, 1969, by the reconstituted Law Commission, which proposed a comprehensive overhaul of the 1898 Code WEB 18. The Code of Criminal Procedure Bill, 1970, was drafted based on these recommendations but lapsed in 1972 due to the dissolution of Parliament. Reintroduced as the Code of Criminal Procedure Bill, 1972, it underwent 125 amendments and was enacted as the CrPC, 1973, receiving presidential assent on January 25, 1974, and coming into force on April 1, 1974 WEB 18. The CrPC consolidated and amended the law relating to criminal procedure, aiming to provide a fair, efficient, and just framework for criminal justice administration WEB 24. Transition to the Bhartiya Nagarik Suraksha Sanhita, 2023. On August 11, 2023, the Bhartiya Nagarik Suraksha Sanhita bill was introduced in the Lok Sabha to replace the CrPC, reflecting the need for a modernized criminal justice system. Enacted on December 26, 2023, the BNSS came into effect on July 1, 2024, introducing reforms such as technology integration, victim-centric provisions, and streamlined procedures WEB 17. While the BNSS builds on the CrPC's foundation, it addresses contemporary challenges, including cybercrime, delays in trials, and the need for gender-sensitive procedures. Objects of the Code of Criminal Procedure, 1973. The CrPC, 1973, was designed to achieve several critical objectives, ensuring a balance between state authority and individual rights. These objectives, rooted in principles of justice, fairness, and efficiency, continue to influence the BNSS. Below are the primary objects, illustrated with examples and supported by landmark case law. Ensuring a fair trial. The foremost objective of the CrPC is to guarantee a fair trial for every accused, aligning with the principles of natural justice and Article 21 of the Constitution of India, which protects the right to life and personal liberty. The CrPC establishes procedures to ensure the accused right to be heard, access legal representation, and receive impartial adjudication WEB 19. Example, Section 304 of the CrPC mandates legal aid for indigent accused persons, ensuring access to justice regardless of economic status. This provision was reinforced in the landmark case of Husainara Khatun v. Home Secretary, State of Bihar, 1979, where the Supreme Court emphasized the right to free legal aid as integral to a fair trial, highlighting the plight of under-trial prisoners unable to afford legal representation. Husainara. BNSS context. The BNSS enhances this objective by mandating time-bound trials and integrating technology, such as virtual hearings, to ensure accessibility and fairness, particularly for marginalized communities. Providing uniform procedure. The CrPC establishes a uniform procedure for the investigation, prosecution, and trial of criminal offenses across India, ensuring consistency and predictability in the justice system. WEB 19. It delineates processes for lodging a first information report, for arrests, bail, and trials, applicable to all offenses under the Indian Penal Code, IPC, and other laws. WEB 24. Example, Section 154 of the CrPC mandates the recording of infer for cognizable offenses, ensuring a standardized starting point for investigations. In Lalita Kumari v. Government of Uttar Pradesh, 2014, the Supreme Court clarified that registration of infer is mandatory for cognizable offenses, reinforcing the CrPC's role in standardizing investigative procedures. Lalita. BNSS context. The BNSS retains this uniformity but introduces provisions for online for registration and electronic evidence submission, adapting to digital advancements while maintaining procedural consistency. Facilitating speedy justice. The CrPC aims to minimize delays in investigations and trials, which can undermine justice and public trust. Provisions such as summary trials, Sections 260-265, and plea bargaining, Sections 51-265A-265L, introduced by the 2005 amendment, were designed to expedite case disposal. WEB 7. Example, in Common Cause v. Union of India, 1996, the Supreme Court addressed delays in criminal trials, directing courts to expedite cases involving serious offenses to prevent injustice to victims and accused alike. Common Cause. The CrPC's provisions for summary trials, applicable to offenses punishable with up to 6 months imprisonment, exemplify this objective. BNSS context. The BNSS prioritizes time-bound investigations and trials, mandating completion within specific periods, e.g., 60 days for certain investigations, to reduce pendency and enhance efficiency. Protecting the rights of the accused. The CrPC safeguards the accused rights, balancing state power with individual liberty. Provisions such as Section 41, Arrest Procedures, Section 50, Informing Grounds of Arrest, and Section 438, Anticipatory Bail, protect against arbitrary detention and ensure due process. WEB 5. Example, in Arnish Kumar v. State of Bihar, 2014, the Supreme Court laid down guidelines for arrests under Section 41, emphasizing that arrests should not be routine and must follow the CrPC's 9-point checklist to prevent abuse of power. Arnish. This case underscored the CrPC's role in protecting personal liberty. BNSS context. The BNSS strengthens these protections by introducing stricter guidelines for arrests and enhancing provisions for anticipatory bail, reflecting a continued commitment to individual rights. Ensuring victim compensation and support. The CrPC introduced provisions for victim compensation to provide just and speedy redress. Sections 357, 357A, 357B, and 357C empower courts to award compensation to victims, addressing their financial and emotional needs. WEB 17. Example, in Ankush Shiva Hegawat v. State of Maharashtra, 2013, the Supreme Court emphasized the importance of victim compensation under Section 357A, directing states to establish victim compensation schemes to support victims of violent crimes. Ankush. This case highlighted the CrPC's victim-centric approach. BNSS context. The BNSS expands victim support by mandating state-funded compensation schemes and ensuring medical treatment for victims of sexual offenses, building on the CrPC's framework. Preventing public nuisance and offenses. The CrPC addresses public order through provisions like Section 144, which empowers magistrates to issue orders to prevent nuisance or apprehended danger. WEB 7. These provisions aim to maintain societal peace and security. Example, in Madhulime v. Subdivisional Magistrate, 1970, the Supreme Court upheld the constitutionality of Section 144, recognizing its necessity for maintaining public order while cautioning against its misuse. Madhulam. 52. BNSS context. The BNSS retains similar provisions but enhances oversight to prevent arbitrary use, ensuring a balance between public safety and individual freedoms. Supporting maintenance of dependents. The CrPC provides mechanisms for the maintenance of spouses, children, and parents under Section 125, ensuring social justice for vulnerable family members. WEB 17. Example, in Savitri Pandey v. Prem Chandra Pandey, 2002, the Supreme Court clarified the scope of maintenance under Section 125, emphasizing its role in preventing destitution and ensuring dignity for dependents. Savitri. BNSS context. The BNSS streamlines maintenance procedures, introducing online filing options and stricter enforcement mechanisms to ensure timely support. Structure and key features of the CrPC. 1973. The CrPC comprises 484 sections, 37 chapters, and 2 schedules, providing a comprehensive framework for criminal justice administration. WEB 9. Key features include, hierarchy of criminal courts. The CrPC establishes a hierarchy, from the Supreme Court to courts of session and magistrates' courts, ensuring clear jurisdictional boundaries. WEB1A. Types of trials. It categorizes trials into sessions, warrants, summons, and summary trials, each tailored to the offense's severity. WEB19. Arrest and bail procedures. Sections 4160 and 436-450 regulate arrests and bail, balancing law enforcement needs with individual rights. WEB5. Investigation and inquiry. Sections 154-176 outline procedures for FIRs, investigations, and inquiries, ensuring systematic evidence collection. WEB8. Appeals and revisions. Sections 372-405 provide mechanisms for appeals and revisions, ensuring judicial oversight. WEB7. Relevance to the Bhartiya Nagarik Suraksha Sanhita, 2023. The BNSS builds on the CrPC's objectives but introduces reforms to address modern challenges. Key changes include, technology integration. The BNSS mandates electronic FIRs, virtual hearings, and digital evidence to enhance efficiency. WEB17. Victim-centric reforms. Expanded compensation schemes and mandatory medical support for victims reflect a stronger focus on restorative justice. Time-bound processes. Strict timelines for investigations and trials aim to reduce pendency and expedite justice. 53 Gender-sensitive provisions. Enhanced protections for women and children, including faster investigations for sexual offenses, address contemporary social concerns. The BNSS retains the CrPC's core principles of fairness, uniformity, and rights protection while adapting to technological and societal changes. For instance, the BNSS's emphasis on digital processes aligns with the CrPC's objective of speedy justice, as seen in cases like Common Cause v. Union of India. Landmark cases shaping CrPC interpretation. Several judicial pronouncements have shaped the CrPC's application, reinforcing its objectives. Maneka Gandhi v. Union of India, 1978 expanded the scope of Article 21, emphasizing that CrPC procedures must comply with due process. Maneka D.K. Basu v. State of West Bengal, 1997 established guidelines for arrests and detentions, reinforcing Section 41's safeguards. Tkavasu Vishekha v. State of Rajasthan, 1997 influenced CrPC amendments for victim support in sexual offense cases, paving the way for BNSS provisions. Vishekha. 54 Question 13, FIR procedure and elements. Discuss the procedure for filing an FIR, First Information Report, under CR.P.C, or BNSS. What are the essential elements of an FIR? Procedure for filing an FIR under BNSS, 2023. The procedure for filing an FIR is governed primarily by Section 173 of the BNSS, which corresponds to Section 154 of the CrPC but introduces modernized provisions. The BNSS emphasizes accessibility, transparency, and technological integration while retaining the core principles of the CrPC. The procedure can be broken down into several stages, as outlined below. Reporting a cognizable offense. A cognizable offense, as defined under Section 2(c) of the BNSS, is an offense for which a police officer may arrest without a warrant and initiate an investigation without prior judicial permission. Any person, whether a victim, witness, or informant, can report such an offense to the officer in charge of a police station. The information can be provided orally or in writing. Oral reporting. If the information is given orally, the police officer is mandated to reduce it to writing and read it back to the informant to ensure accuracy. The informant must sign the document to authenticate it. Section 173, 1, BNSS. Written reporting. If the informant submits a written complaint, it is directly recorded as the FIR. Electronic filing, e-FIR. The BNSS introduces the provision for filing FIRs through electronic communication under Section 173, 1. This aligns with the Digital India Initiative, making the process more accessible. The informant must sign the e-FIR within 3 days to formalize it. The police must record the information in a prescribed format, as specified by the state government. Special provisions for vulnerable groups. The BNSS incorporates specific safeguards for vulnerable groups, ensuring inclusivity and sensitivity. Women victims, for offenses listed under Sections 64, 65, 66, 67, 68, 69, 70, 71, 74, 75, 76, 77, 78, 79, or 124 of the Bhartiya Nagarik Sanhita, 2023, BNS, such as rape, sexual harassment, or acid attacks. The FIR must be recorded by a female police officer or an authorized female officer, Section 173, 1, BNSS. Persons with disabilities, if the informant is temporarily or permanently mentally or physically disabled, the FIR must be recorded at their residence or a location of their convenience, 55 with the assistance of an interpreter or special educator if required. The process must be videographed, Section 173, 1, BNSS. 0 FIR. The concept of zero FIR, introduced under the BNSS, allows an FIR to be filed at any police station, irrespective of jurisdiction. The police station receiving the complaint must register the FIR and transfer it to the appropriate station for investigation. This provision, rooted in the 2013 Justice Verma Committee recommendations, ensures that victims are not denied justice due to jurisdictional issues. Preliminary inquiry for certain offenses punishable with imprisonment of 3 to 7 years, the BNSS permits a preliminary inquiry before registering an FIR, Section 173, 3. This inquiry, to be conducted within 14 days, determines whether a prima facie case exists, preventing frivolous complaints. However, for serious offenses, immediate registration is mandatory. Recording and documentation. The police officer must enter the FIR into a designated book in a format prescribed by the state government. A copy of the FIR must be provided free of cost to the informant immediately upon registration, Section 173, 2, BNSS. If the police refuse to register an FIR, the informant can approach the superintendent of police or a magistrate under Section 175 of the BNSS. Investigation post FIR. Once the FIR is registered, the police initiate an investigation under Chapter 13 of the BNSS. For specific offenses, such as those under Sections 64 to 71 of the BNS or the Protection of Children from Sexual Offenses Act, 2012, the investigation must be completed within 2 months, Section 193, 2, BNSS. Essential elements of an FIR. An FIR must contain specific elements to be legally valid and effective in initiating an investigation. These elements, derived from statutory provisions and judicial interpretations, are: 1. Information about a cognizable offense. The FIR must pertain to a cognizable offense, as defined under Section 2, c, of the BNSS. It should provide details of the offense, such as the nature of the crime, the act committed, and the relevant legal provisions. 2. Identity of the informant. The FIR must include the name and particulars of the informant, whether a victim, witness, or third party. Anonymous FIRs are generally not entertained unless they disclose credible information about a serious offense. 56.3. Details of the incident. The FIR should specify the date, time, and place of the incident, along with a factual narration of the events. Vague or ambiguous information may weaken its evidentiary value. 4. Identity of the accused. If known. If the accused is known, their details should be included. However, an FIR can be registered even if the accused is unidentified at the time of filing. 5. Signature of the informant. The informant must sign the FIR to authenticate the information, whether it is recorded in writing or electronically, Section 173, 1, BNSS. 6. Recording by police. The FIR must be recorded by the officer in charge of the police station or an authorized officer, ensuring compliance with procedural requirements. Judicial interpretations and leading cases. The judiciary has played a pivotal role in shaping the legal framework surrounding FIRs, ensuring their proper registration and preventing misuse. Below are key landmark cases that elucidate the procedure and essential elements of an FIR. Lalita Kumari v. Government of Uttar Pradesh, 2014, 2 SCC 1. In this landmark judgment, the Supreme Court addressed the mandatory registration of FIRs for cognizable offences. The case arose when the police refused to register an FIR for a minor girl's kidnapping, prompting the court to lay down guidelines. Registration of an FIR is mandatory under Section 154 of the CrPC, now Section 173 of the BNSS, if the information discloses a cognizable offence. No preliminary inquiry is permissible unless the information is vague or does not clearly disclose a cognizable offence. For offences punishable with 3 to 7 years of imprisonment, a preliminary inquiry may be conducted within 7 days, now 14 days under BNSS. Failure to register an FIR can lead to disciplinary action against the police officer and judicial intervention by a magistrate. This case reinforced the citizens' right to access justice and emphasized the police's duty to act promptly. D.K. Basu v. State of West Bengal, 1997, 1 SCC 416. This case focused on protecting the rights of individuals during arrest and investigation following an FIR. The Supreme Court issued guidelines to prevent custodial abuse, including, police officers must wear visible identification badges during arrests. 57. An arrest memo must be prepared, signed by a witness and the arrestee. The arrestee's family must be informed of the arrest. These guidelines, now incorporated into the BNSS, ensure transparency and accountability in the investigation process post-FIR. Youth Bar Association of India v. Union of India, 2016, 9 SCC 516. This case mandated that a copy of the FIR be provided to the informant free of cost and uploaded on the police website within 24 hours, except in sensitive cases. This ruling is reflected in Section 173, 2, of the BNSS, enhancing public access to FIRs and promoting transparency. T. Anthony v. State of Kerala, 2001, 6 SCC 181. The Supreme Court clarified the concept of zero FIR, stating that an FIR can be registered at any police station, regardless of jurisdiction, and must be transferred to the appropriate station. This principle is codified in the BNSS, ensuring victims are not turned away due to jurisdictional constraints. Analysis and contemporary relevance. The BNSS introduces several progressive changes to the FIR process, aligning with the goal of a citizen-centric criminal justice system. The provision for e-FIRs addresses the challenges of physical access to police stations, particularly in rural areas. The mandatory videography of FIRs for persons with disabilities reflects sensitivity toward marginalized groups. The zero FIR provision eliminates jurisdictional barriers, as seen in cases like T. Anthony, ensuring timely justice delivery. However, challenges remain. False FIRs, as discussed in State of Haryana v. Bajan Lal, 1992, Sup. 1, SCC 335, can lead to harassment and wrongful arrests. The BNSS addresses this by allowing preliminary inquiries for certain offences and imposing penalties for false complaints under the BNS. Additionally, the judiciary's role in overseeing FIR registration, as established in Lalita Kumari, ensures checks and balances. The integration of forensic investigation for offences punishable with 7 years or more, Section 176, BNSS, enhances the quality of investigations triggered by FIRs. The emphasis on timelines, such as completing investigations within 2 months for specific offences, addresses delays in the justice system. 58. Question 14. Inquiries and trials in criminal court jurisdiction. What are inquiries and trials in the jurisdiction of the criminal court? Explain in detail. Defining inquiries and trials. Inquiry under Section 2, 1, I, of the BNSS, an inquiry is defined as any proceeding, other than a trial, conducted by a magistrate or court to ascertain facts or determine the truth of a matter. Inquiries are preliminary in nature and include processes such as investigations into complaints, bail applications, or committal proceedings. For instance, An inquiry under Section 223 of the BNSS involves a magistrate examining a complaint to decide whether to proceed with a trial. A trial is the judicial adjudication of an offense, culminating in a verdict of guilt or acquittal. The BNSS categorizes trials into several types, including sessions trials, Section 248, warrant cases, Sections 259-266, summons cases, Sections 274-280, and summary trials, Sections 283-287. Trials involve the examination of evidence, witness testimonies, and legal arguments to determine the accused culpability. The distinction between inquiries and trials lies in their purpose and outcome. Inquiries are fact-finding processes that may or may not lead to a trial, while trials are conclusive adjudications. For example, in a case of alleged theft, a magistrate may conduct an inquiry to verify the complaint's prima facie validity before committing the case to a sessions court for trial. Jurisdiction of criminal courts. Jurisdiction defines a court's authority to hear and decide cases, encompassing territorial, pecuniary, and subject matter dimensions. The BNSS delineates the jurisdiction of criminal courts under Chapter 2, Section 620, and Chapter 15, Sections 197-206, ensuring that inquiries and trials are conducted within appropriate legal and territorial bounds. Types of jurisdiction. Territorial jurisdiction, Section 197 stipulates that an offense is ordinarily inquired into and tried by a court within whose local jurisdiction it was committed. For example, if a robbery occurs in New Delhi, the local magistrate's court in that area has jurisdiction. Subject matter jurisdiction, different courts handle specific offenses based on their severity. Magistrates' courts try minor offenses, while sessions courts handle graver offenses like murder, Section 8. 59. Personal jurisdiction, courts may exercise jurisdiction over individuals based on their residence or the location of the offense's consequences, as per Section 198. Hierarchy of courts. The BNSS retains the CrPC's hierarchical structure. Magistrates' courts handle inquiries and trials for less serious offenses, Section 9. Sessions courts try serious offenses and hear appeals from magistrates' courts, Section 8. High courts exercise appellate and inherent jurisdiction, Section 6. Supreme Court hears appeals and exercises original jurisdiction in specific cases, Section 6. Inquiries under the BNSS. Inquiries are critical to the pre-trial phase, ensuring that only meritorious cases proceed to trial. The BNSS introduces modernized provisions to enhance efficiency and fairness. Types of inquiries. Inquiry into cognizable offenses, Section 173, 3, allows a police officer to conduct a preliminary inquiry to ascertain a prima facie case before registering an FIR. For example, in a case of alleged fraud, the police may verify documents before proceeding. Committal inquiries, Section 232 mandates magistrates to inquire into cases triable by sessions courts to determine if sufficient grounds exist for committal. In State of Bihar v. Ramesh Singh, AIR 1977 SC 2018, the Supreme Court held that committal inquiries must establish a prima facie case without weighing evidence as in a trial. Inquiries into complaints, under Section 223, a magistrate examines complaints to decide whether to summon the accused or dismiss the case. For instance, in a defamation case, the magistrate assesses the complaint's validity before proceeding. Procedural aspects. The BNSS emphasizes technology and expediency in inquiries. Electronic mode, Section 530 allows inquiries to be conducted electronically, facilitating remote hearings. For example, during the COVID-19 pandemic, courts used video conferencing for bail inquiries. Forensic evidence, Section 176 mandates forensic investigation for offenses punishable by 7 years or more, ensuring robust evidence collection during inquiries. 60 trials under the BNSS. Trials under the BNSS are structured to ensure fair and expeditious adjudication, with provisions tailored to different offense categories. Types of trials. Sessions trials, governed by sections 248-258, these trials handle serious offenses like murder. The process includes framing charges, examining witnesses, and pronouncing judgment. In Kahar Singh v. State, Delhi Administration, Air 1988 SC 1883, a leading case on the assassination of Indira Gandhi, the Sessions Court conducted a meticulous trial, upheld by the Supreme Court. Warrant cases, sections 259-266 outline procedures for cases punishable by imprisonment exceeding 2 years. For example, in a case of theft under section 303 of the Bhartiya Nagarik Sanhita, 2023, BNS, the magistrate follows a structured process of evidence examination. Summons cases, sections 274-280 apply to minor offenses, with a simplified procedure. For instance, a traffic violation case may be resolved through a summary trial under section 283. Summary trials, sections 283-287 allow quick disposal of petty cases, such as public nuisance, with imprisonment not exceeding 3 months. Innovations in trials. The BNSS introduces several reforms. Trial in absentia, section 356 allows trials to proceed against proclaimed offenders who abscond, ensuring justice is not stalled. For example, if an accused flees abroad, the court may pronounce judgment based on available evidence. Digital evidence, section 530 permits the use of electronic communication devices as evidence, reflecting technological advancements. Bail reforms, section 479 provides for bail for first-time offenders after 1/3 of the maximum imprisonment period, promoting fairness. Jurisdictional challenges and solutions. The BNSS addresses complex jurisdictional issues, particularly for offenses transcending geographical boundaries. 61 Multi-jurisdictional offenses. Section 198 provides flexibility for offenses committed across multiple jurisdictions or during a journey, section 203. For example, in a cybercrime case where a hacker in Mumbai targets a victim in Chennai, the BNSS allows the court in either jurisdiction to try the case. Conflict of jurisdiction. Section 206 resolves conflicts when multiple courts take cognizance of the same offense. The High Court with appellate jurisdiction decides the appropriate court. In Y. Abrahamajith v. Inspector of Police, Chennai, Air 2004 SC 4286, the Supreme Court clarified that jurisdiction lies where the offense's consequences are felt, a principle reflected in the BNSS. Leading case, Satvinder Singh Saluja v. State. In Satvinder Singh Saluja v. State, Government of NCT of Delhi, 2020 SCC Online SC 636, the Supreme Court addressed jurisdictional issues in a check bounce case under the Negotiable Instruments Act, 1881. The court held that jurisdiction lies where the check was dishonored, a principle analogous to BNSS provisions for determining territorial jurisdiction based on the offense's impact. Practical examples. 1. Inquiry example. In a case of alleged domestic violence under Section 85 of the BNS, a magistrate conducts an inquiry under Section 223 to verify the complainant's allegations, examining medical reports and witness statements before summoning the accused. 2. Trial example. In a murder case, the Sessions Court follows Section 248, framing charges, examining forensic evidence, e.g., DNA samples, and pronouncing judgment, as seen in Kahar Singh v. State. 62. Question 15. Definition and grant of bail. Define bail and explain the circumstances in which bail is granted. Explain with the help of case laws. Definition of bail. Bail refers to the temporary release of an accused person from custody, typically on conditions that ensure their appearance in court and compliance with legal processes. The term bail derives from the French word bailir, meaning to deliver or to give, reflecting the act of entrusting the accused to the custody of sureties or conditions rather than detention. WEB 19. In Indian law, Bail is a mechanism to safeguard the accused's constitutional right to personal liberty under Article 21 while ensuring the administration of justice is not obstructed. Under the BNSS, bail is categorized into three types, mirroring the CrPC's framework: regular bail, granted to a person in custody during investigation, inquiry, or trial, sections 479-484, BNSS. Anticipatory bail, sought before arrest to prevent detention in cases of apprehended arrest, section 482, BNSS. Interim bail, temporary relief granted pending the final decision on a bail application WEB 17. The BNSS defines bail as a judicial or statutory process whereby an accused is released upon furnishing a bond, with or without sureties, to ensure their presence at subsequent proceedings. This definition aligns with the CrPC's provisions but incorporates modern safeguards, such as stricter conditions for habitual offenders and technology-enabled monitoring WEB 7. Circumstances for granting bail. The BNSS, like the CrPC, distinguishes between bailable and non-bailable offenses, with specific provisions governing bail decisions. The circumstances under which bail is granted depend on the nature of the offense, the stage of the criminal process, and judicial discretion. Below, we explore these circumstances, supported by examples and case laws. Bailable offenses. In bailable offenses, as listed in the first schedule of the BNSS, the accused has a statutory right to bail under section 479. These offenses are typically less severe, with punishments not exceeding 7 years or fines. The police or court must grant bail upon the accused furnishing a bond, with or without sureties WEB 8. Example, an accused charged with theft, section 378, Bhartiya Nagarik Sanhita, 2023, replacing the IPC, is entitled to bail under section 479, BNSS, as theft is a bailable offense unless compounded with aggravating factors. 63 Case law. In LL.B v. Kishore, 2009, the Supreme Court clarified that for bailable offenses, bail is a right, not a privilege, and courts cannot impose onerous conditions that undermine this right. LL.B. The BNSS retains this principle, ensuring automatic bail for bailable offenses with minimal discretion. Non-bailable offenses. For non-bailable offenses, bail is not a right but a matter of judicial discretion under section 480, BNSS. Courts consider factors such as the severity of the offense, the accused criminal history, the likelihood of absconding, and the risk of tampering with evidence or witnesses. WEB 19. Section 480, 1, specifies that bail may be refused if there are reasonable grounds to believe the accused is guilty of an offense punishable with death or life imprisonment, particularly for habitual offenders. Example, in a case of murder, section 302, BNS, the court may deny bail if the prosecution presents strong prima facie evidence, such as eyewitness testimony or forensic proof, indicating the accused guilt. Case law. In Prahlad Singh Bhatti v. NCT of Delhi, 2001, the Supreme Court outlined factors for granting bail in non-bailable offenses, including the nature of the accusation, the severity of punishment, and the accused character. Prahlad. The BNSS codifies similar considerations, emphasizing proportionality and fairness. Bail during investigation. During the investigation stage, bail may be granted if the accused is not a flight risk or a threat to the investigation. Section 41A, BNSS, akin to Section 41A, CrPC, mandates a notice of appearance before arrest in cases with punishment less than 7 years, reducing the need for custodial detention. WEB 17. Example, an accused in a cheating case, Section 420, BNS, may be granted bail during investigation if they cooperate with the police and there is no risk of evidence tampering. Case law. In Arnish Kumar v. State of Bihar, 2014, the Supreme Court held that arrests in offenses punishable with less than 7 years should be avoided unless necessary, and bail should be considered to prevent arbitrary detention. Arnish. The BNSS reinforces this by mandating reasons for arrest, aligning with judicial directives. Bail during trial. Once a trial commences, courts may grant bail if the accused has been in custody for a prolonged period or if the trial is delayed. Section 479, BNSS, allows courts to release the accused on bail if detention exceeds half the maximum punishment prescribed for the offense WEB 7. Example, an accused charged with grievous hurt, Section 325, BNS, may be granted bail if detained for over 3 years, half of the 7-year maximum punishment, and the trial is ongoing. Case law, in Husainara Khatun v. Home Secretary, State of Bihar, 1979, the Supreme Court emphasized that prolonged detention without trial violates Article 21, directing courts to grant bail in such cases. Husainara. The BNSS incorporates time-bound trial mandates to prevent such delays. 64 Anticipatory bail. Section 482, BNSS, allows individuals apprehending arrest in non-bailable offenses to seek anticipatory bail. Courts grant such bail if there is no prima facie case, the accusation appears mala fide, or the accused is unlikely to abscond. WEB. Example, a public servant accused of corruption under the Prevention of Corruption Act may seek anticipatory bail if the allegations appear politically motivated and lack credible evidence. Case law, in Gurbakshar Singh Sibia v. State of Punjab, 1980, the Supreme Court held that anticipatory bail is a tool to protect personal liberty and should be granted liberally unless compelling reasons exist to deny it. Gurbakshar. The BNSS retains this provision, with added safeguards against misuse, such as mandatory court appearances. Default bail. Section 482, BNSS, provides for default, statutory, bail if the police fail to file a charge sheet within the prescribed period 60 days for offenses punishable with less than 7 years and 90 days for graver offenses. WEB 17. Example, an accused in a robbery case, Section 392, BNS, is entitled to default bail if the police do not file a charge sheet within 90 days of arrest. Case law, in Rakesh Kumar Paul v. State of Assam, 2017, the Supreme Court clarified that default bail is a statutory right under Section 167, 2, CrPC, now Section 482, BNSS, and courts cannot deny it if the prosecution fails to meet the deadline. Rakesh. The BNSS strengthens this right by mandating stricter compliance by investigating agencies. Special considerations for vulnerable groups. The BNSS introduces specific provisions for women, minors, and first-time offenders, reflecting a humane approach to bail. Section 479, 3, directs courts to consider leniency for these groups unless the offense is heinous. WEB 7. Example, a woman accused of a non-heinous offense, such as criminal breach of trust, may be granted bail with lenient conditions, considering her familial responsibilities. Case law, in Sheila Bars v. State of Maharashtra, 1983, the Supreme Court advocated for special consideration for women and juveniles in custody, influencing BNSS provisions for vulnerable groups. Sheila. Bail in economic offenses and organized crime. For economic offenses and organized crime, the BNSS imposes stricter conditions, requiring courts to ensure the accused does not influence witnesses or tamper with evidence. WEB 17. Example, in a money laundering case under the Prevention of Money Laundering Act, bail may be denied if the accused has significant financial influence that could obstruct justice. Case law, in Y.S. Jagan Mohan Reddy v. CBI, 2013, the Supreme Court denied bail in an economic offense case due to the accused potential to influence witnesses, a principle reflected in BNSS's stringent conditions. Jagan. 65 factors influencing bail decisions. Courts exercise discretion in bail decisions based on several factors, as outlined in judicial precedents and BNSS provisions: nature and gravity of the offense. Heinous offenses like murder or terrorism warrant stricter scrutiny. Prelude. Prima facie evidence. Courts assess the strength of the prosecution's case. Gurbakshar. Accused background, criminal history, social ties, and likelihood of absconding are considered arnish. Public interest, bail may be denied if it risks public safety or justice administration jigan. Health and age, medical conditions or old age may favor bail shila. Judicial guidelines and BNSS reforms. The BNSS builds on CrPC's bail framework, incorporating judicial guidelines from landmark cases. Key reforms include, technology integration. Courts may impose GPS monitoring as a bail condition to track the accused WEB17. Time-bound processes. The BNSS mandates prompt disposal of bail applications to prevent prolonged detention. Victim-centric approach. Courts must consider the victim's perspective, especially in sexual offense cases, before granting bail. Landmark case laws shaping bail jurisprudence. Several Supreme Court decisions have shaped bail jurisprudence, influencing BNSS provisions. Modi Ram v. State of Madhya Pradesh, 1978 held that bail conditions must be reasonable and not disproportionately burden the poor. Modi Ram Sanjay Chandra v. CBI, 2012 emphasized that bail is the rule and jail is the exception in non-bailable offenses, promoting liberal bail policies. Sanjay D.K. Basu v. State of West Bengal, 1997 established safeguards against arbitrary arrests, influencing BNSS's arrest and bail provisions. T.K. Basu. 66 Question 16, Short notes on complaint and summary trial. Write a short note on the following. I. Complaint to magistrate. 2. Summary trial. Complaint to magistrate. Definition and legal framework. A complaint to a magistrate is a formal allegation made to a judicial authority, typically a judicial magistrate, to initiate criminal proceedings for an offense, whether cognizable or non-cognizable. Under Section 2(d) of the BNSS, a complaint is defined as any allegation made orally or in writing to a magistrate, with a view to his taking action under the Sanhita, that some person, whether known or unknown, has committed an offense, but does not include a police report. This provision corresponds to Section 2(d) of the CrPC but is integrated into the BNSS's citizen-centric framework. The procedure for filing and processing a complaint is governed by Sections 223 to 226 of the BNSS, which outline the steps for examination, inquiry, and trial initiation. Procedure for filing a complaint. 1. Submission of complaint. The complainant, who may be a victim, witness, or any person with knowledge of the offense, submits a complaint to a magistrate, either orally or in writing. Written complaints must be signed by the complainant, Section 223, BNSS. 2. Examination of complainant. Upon receiving the complaint, the magistrate examines the complainant and any witnesses on oath to ascertain the truthfulness of the allegations, Section 223, 1, BNSS. The examination is reduced to writing and signed by the complainant and witnesses. 3 options available to the magistrate. After examination, the magistrate may take cognizance. If the complaint discloses a prima facie case, the magistrate takes cognizance under Section 210 of the BNSS and proceeds with issuing a summons or warrant, Section 223, 2. Direct an inquiry. For complex cases, the magistrate may direct a preliminary inquiry by the police or another person to verify the allegations, Section 224, BNSS. Dismiss the complaint. If no prima facie case is established, the magistrate may dismiss the complaint under Section 226, recording reasons for the dismissal. For police investigation, if the complaint relates to a cognizable offense, the magistrate may direct the police to investigate under Section 175, 3, of the BNSS, ensuring alignment with the First Information Report, FIR, process. 67.5. Trial initiation. Upon finding sufficient grounds, the magistrate issues process, summons or warrant, to the accused, initiating trial proceedings under Chapter 19 of the BNSS. Essential features. Accessibility. Complaints can be filed for both cognizable and non-cognizable offenses, making this mechanism accessible when police refuse to register and FIR. Judicial oversight. The magistrate's examination ensures judicial scrutiny, preventing frivolous complaints. Flexibility. The BNSS allows complaints to be filed by any person, not necessarily the victim, broadening access to justice. Judicial interpretations. The Supreme Court has clarified the scope of complaints to magistrates in several landmark cases. Bajan Lal v. State of Haryana, 1992, Sup. 1, SCC 335. This case outlined guidelines for quashing FIRs and complaints that are frivolous or mala fide. The court emphasized that magistrates must exercise caution in taking cognizance to prevent abuse of the judicial process. For example, a complaint alleging cheating under Section 318 of the Bhartiya Nagarik Sanhita, 2023, BNS, must disclose specific facts constituting the offense to avoid dismissal. Priyavrat Singh v. Shyamji Sahai, 2008, 8 SCC 232, the Supreme Court held that a magistrate must conduct a thorough examination under Section 200 of the CrPC, now Section 223 of the BNSS, to ensure the complaint is not vexatious. This case involved a complaint of criminal breach of trust, where the magistrate's failure to examine witnesses led to the complaint's dismissal. Example: suppose a shopkeeper files a complaint alleging that a customer issued a check that bounced, constituting an offense under Section 138 of the Negotiable Instruments Act, 1881. The magistrate examines the shopkeeper and the bank official as a witness, verifies the check and notice served, and takes cognizance, issuing a summons to the accused. If the complaint lacks evidence, such as proof of notice, the magistrate may dismiss it under Section 226. Summary trial definition and legal framework. A summary trial is a streamlined procedure for adjudicating minor offenses to ensure swift justice delivery, reducing judicial backlog. Under the BNSS, summary trials are governed by Sections 283-68 to 287, corresponding to Sections 260 to 265 of the CrPC. These provisions allow magistrates to try certain offenses summarily, ensuring expeditious disposal without compromising fairness. Section 283, 1, of the BNSS empowers judicial magistrates of the first class, chief judicial magistrates, or specially empowered magistrates to conduct summary trials for offenses punishable with imprisonment up to 2 years, fine, or both. Offenses triable summarily. Section 283, 2, specifies the offenses suitable for summary trials, including offenses not punishable with death, life imprisonment, or imprisonment exceeding 2 years. Theft under Section 303 of the BNS, where the value of stolen property does not exceed 2,000 rupees. Receiving stolen property under Section 317 of the BNS. Insult with intent to provoke breach of peace under Section 352 of the BNS. Criminal intimidation under Section 351, 1, of the BNS, if not involving grave threats. Offenses under specific statutes, such as the Motor Vehicles Act, 1988. Procedure for summary trial. The procedure for summary trials under Sections 283 to 287 of the BNSS is as follows: 1. Initiation. The magistrate, on finding the case suitable for summary trial, informs the accused and seeks their consent, as the procedure is optional, Section 283, 1. 2. Recording of particulars. The magistrate records the substance of the evidence and the plea of the accused in a summary manner, without detailed documentation, Section 284. 3. Trial process. The trial follows a simplified process, with examination of witnesses and cross-examination conducted expeditiously. The accused may plead guilty or not guilty, Section 285. 4. Judgment. The magistrate delivers a brief judgment, stating the offense, findings, and sentence. If the accused is convicted, the sentence cannot exceed 3 months imprisonment or a fine, Section 286. 5. Record keeping. The record is maintained in a prescribed format, and no appeal lies against a conviction unless the sentence exceeds 3 months or the trial is conducted irregularly, Section 287. 69 Essential features. Expediency. Summary trials prioritize speed, typically concluding within a few hearings. Limited scope. Only minor offenses with low punishment thresholds are triable summarily. Judicial discretion. Magistrates have the discretion to opt for summary trials, ensuring flexibility. Restricted sentencing. The maximum imprisonment is capped at 3 months, safeguarding fairness. Judicial interpretations. The judiciary has emphasized the balance between speed and justice in summary trials. Kailash v. Bhartiya v. Rajesh Kumar, 2014, 14 SCC 570. The Supreme Court held that summary trials must adhere to principles of natural justice, including the right to a fair hearing. In this case, a summary trial for an offense under Section 147 of the Negotiable Instruments Act was set aside due to inadequate opportunity for the accused to present their defense. State of Maharashtra v. Atmaram, 1978, 2 SCC 8, the court clarified that summary trials are suitable for petty offenses but require meticulous recording of evidence to avoid prejudice. This case involved a summary trial for a minor theft, where improper documentation led to the case being remanded. Example: consider a case where an individual is charged with petty theft under Section 303 of the BNS for stealing goods worth 1500. The magistrate, finding the offense suitable for summary trial, obtains the accused consent, examines the complainant and a witness, and records the accused plea. If the accused pleads guilty, the magistrate may impose a fine or short-term imprisonment. If the accused contests, a brief trial is conducted, concluding within days. Analysis and contemporary relevance. The BNSS enhances the complaint to magistrate mechanism by retaining the CrPC's core principles while emphasizing accessibility and judicial oversight. The provision for directing police investigations under Section 175(3) aligns complaints with the fair process, ensuring seamless justice delivery. Landmark cases like Bajan Lal underscore the need to filter frivolous complaints, protecting the accused from harassment. Summary trials under the BNSS address the backlog of minor cases, promoting efficiency without sacrificing fairness. The cap on sentencing and the requirement for accused consent reflect a balanced approach. However, judicial precedents like Kailash v. Bhartiya highlight the need for procedural rigor to prevent miscarriage of justice. 70. The BNSS's technological integrations, such as electronic filing of complaints, Section 223, and its focus on victim rights, such as mandatory videography for vulnerable groups, enhance these mechanisms' efficacy. Challenges remain, including ensuring magistrates' training for summary trials and preventing misuse of complaints for personal vendettas. 71. Question 17. Procedure of trial before a court of session. Explain in detail the procedure of trial before a court of session. Jurisdiction of the court of session. The court of session, established under Section 8 of the BNSS, exercises jurisdiction over offenses punishable with death, life imprisonment, or imprisonment exceeding 7 years, as specified in the Bhartiya Nagarik Sanhita, 2023, BNS. It also hears appeals and revisions from subordinate courts, Section 9. The territorial jurisdiction is governed by Section 197, which mandates that offenses are tried where they were committed, unless otherwise provided, e.g., Section 198 for multi-jurisdictional offenses. For instance, in a murder case under Section 103 of the BNS, committed in Mumbai, the Sessions Court in Mumbai has jurisdiction. The BNSS retains the CrPC's hierarchical structure, positioning Sessions Courts above Magistrates' Courts but below High Courts, ensuring specialized adjudication for grave offenses. Overview of Sessions Trial Procedure. The Sessions Trial Procedure under the BNSS is a structured process designed to ensure thorough examination of evidence and arguments. It comprises several stages, from committal to judgment, each governed by specific provisions to safeguard the accused rights and uphold justice. Sections 248 to 258 outline the procedural framework, supplemented by innovations like electronic evidence and trials in absentia. Stages of sessions: trial: committal of case to sessions court. The trial process begins with the committal of a case by a magistrate under Section 232 of the BNSS. Cases triable exclusively by a court of session, e.g., murder, rape, are committed after the magistrate conducts a preliminary inquiry to establish a prima facie case. The magistrate forwards the case record, including the charge sheet, Section 193, and evidence, to the Sessions Court. In State of Bihar v. Ramesh Singh, Air 1977 SC 2018, the Supreme Court clarified that committal proceedings are not a trial but a screening mechanism to prevent frivolous cases from reaching the Sessions Court. For example, in a dacoity case under Section 305 of the BNS, the magistrate examines witness statements and forensic reports before committal. Framing of charges: upon receiving the case, the sessions judge reviews the record and frames charges under Section 250. The charge must specify the offense, its legal provisions, and particulars, e.g., time, place. The accused is informed of the charges, which are read and explained, and asked to plead guilty or not guilty. 72. If the accused pleads guilty, the court may convict them under Section 252, ensuring the plea is voluntary. In Kahar Singh v. State, Delhi Administration, Air 1988 SC 1883, involving the assassination of Indira Gandhi, the Sessions Court meticulously framed charges under Sections 302 and 120B of the Indian Penal Code, 1860, now Section 103 and 61, 2, of the BNS, ensuring clarity. If the accused pleads not guilty, the trial proceeds. For instance, in a rape case under Section 64 of the BNS, the court frames charges based on the victim's statement and medical evidence. Prosecution's case: the prosecution opens its case under Section 251, outlining the evidence to prove the accused guilt. The BNSS mandates the examination of prosecution witnesses, Section 253, who are cross-examined by the defense. Documentary and electronic evidence, such as CCTV footage, are admissible under Section 530. In a hypothetical murder case, the prosecution may present the murder weapon, forensic DNA reports, and eyewitness testimonies. The BNSS emphasizes forensic evidence, Section 176, requiring mandatory forensic examination for offenses punishable by 7 years or more, enhancing evidentiary reliability. Statement of the accused: after the prosecution's case, the accused is examined under Section 349, replacing Section 313 of the CrPC. The court questions the accused on the evidence presented, allowing them to explain or refute allegations. This statement is not under oath, and no adverse inference is drawn from silence. In Nandini Satpathy v. P.L. Dani, Air 1978 SC 1025, the Supreme Court emphasized that Section 313, now Section 349, protects against self-incrimination, ensuring fairness. For example, in a robbery case, the accused may claim an alibi, which the court considers without compelling incriminatory answers. Defense evidence: if the accused wishes, they may present defense evidence under Section 253. Defense witnesses are examined and cross-examined, and documentary evidence is submitted. The BNSS allows flexibility, enabling the accused to counter prosecution claims effectively. In a case of culpable homicide under Section 105 of the BNS, the defense may present medical reports to argue the act was unintentional, supported by witness testimonies. Arguments and judgment: after evidence is closed, both parties present arguments under Section 254. The prosecution summarizes its case, while the defense highlights inconsistencies or legal defenses. The court then pronounces judgment under Section 255, acquitting or convicting the accused. 73. If convicted, the court hears arguments on sentencing, Section 256. The BNSS introduces victim compensation, Section 396, ensuring restorative justice. In Bakhan Singh v. State of Punjab, Air 1980 SC 1325, the Supreme Court established the rarest of rare doctrine for death penalty cases, a principle applicable under Section 243 for sessions trials. For example, in a kidnapping case, the court may convict under Section 137 of the BNS and impose imprisonment, considering the accused criminal history and victim impact. Post-judgment remedies. Post-judgment, the accused may appeal to the High Court under Section 415. The BNSS allows the Sessions Court to suspend the sentence pending appeal, Section 432. In KM Nanavati v. State of Maharashtra, Air 1962 SC 605, the accused appealed a naval officer's conviction, highlighting procedural irregularities, demonstrating the appellate recourse available. Innovations in sessions trials under BNSS. The BNSS introduces reforms to enhance the sessions trial process. Trial in absentia, Section 356 allows trials against absconding accused, ensuring justice is not stalled. For instance, if an accused flees abroad in a terrorism case, the court may conduct the trial based on available evidence. Electronic trials, Section 530 permits video conferencing for witness examination, as seen during the COVID-19 pandemic when courts conducted remote hearings. Forensic mandates, Section 176 requires forensic reports, reducing reliance on oral testimony. Bail reforms, Section 479 provides for bail for first-time offenders after one-third of the maximum imprisonment period, balancing rights and justice. Landmark case, Kahar Singh v. State, Delhi Administration. In Kahar Singh v. State, Delhi Administration, Air 1988 SC 1883, the Sessions Court conducted a high-profile trial for the assassination of Prime Minister Indira Gandhi. The accused, framed under Sections 302 and 120b of the IPC, now Section 103 and 61, 2, of the BNS, underwent a rigorous process. Committal, the magistrate committed to the case after verifying evidence like bullet casings and witness statements. Charges, the Sessions Court framed charges, detailing the conspiracy and execution. Evidence, prosecution presented forensic evidence and accomplice testimonies, cross-examined by the defense. 74 Judgment, the court convicted the accused, sentencing them to death, upheld by the Supreme Court. This case exemplifies the Sessions trial's meticulousness, ensuring due process even in politically sensitive cases. Practical examples. 1. Example 1, in a rape case under Section 364 of the BNS, the magistrate commits the case to the Sessions Court after reviewing the victim's statement and DNA evidence. The Sessions Court frames charges, examines the victim via video conferencing, Section 530, and convicts based on forensic reports, ordering victim compensation, Section 396. 2. Example 2, in a murder case under Section 103 of the accused pleads not guilty. The Sessions Court presents eyewitnesses, CCTV footage, and forensic evidence, while the defense argues self-defense. The court acquits, citing insufficient evidence to prove intent, illustrating Section 255's impartiality. Critical analysis. The BNSS's Sessions trial procedure is robust but faces challenges. Strengths, the emphasis on forensic evidence and electronic trials enhances accuracy and accessibility. Trial in absentia addresses delays caused by absconding accused. Challenges, the provision for hearing the accused before cognizance, Section 225, may delay proceedings, as noted by legal scholar advocate Kushal Mor. Limited plea bargaining options, Section 289, restrict non-trial resolutions. Judicial safeguards, Cases like D.K. Basu v. State of West Bengal, Air 1997 SC 610, reinforce procedural protections, reflected in BNSS provisions like mandatory for recording, Section 173. 75 Question 18, Short notes on reference, revision, and appellate powers. Write a short note on the following. I. Difference between reference and revision. 2. Powers of the appellate court. Difference between reference and revision. Reference under BNSS definition and legal framework. Reference is a procedure under Section 435 of the BNSS, corresponding to Section 395 of the CrPC, whereby a subordinate court refers a case to a higher court, typically the High Court, for guidance on a question of law or the validity of any act, ordinance, or regulation. The purpose is to seek clarification to ensure correct application of the law in a pending case. Key features. Nature. Reference is a consultative mechanism initiated by a subordinate court, not a party to the case. Scope. It is limited to questions of law, such as the interpretation of a statute or the validity of a legal provision, and does not involve re-examination of facts. Initiation. The court, Sessions Court, Magistrate, or other subordinate court, refers the case suo motu when it encounters a legal ambiguity, Section 435, 1, BNSS. Jurisdiction. The High Court typically exercises reference jurisdiction, delivering an opinion that is binding on the referring court, Section 435, 2. Outcome. The High Court's opinion guides the subordinate court in disposing of the case, but it does not result in a final judgment on the case itself. Example. Suppose a magistrate is trying a case under Section 303 of the Bhartiya Nagarik Sanhita, 2023, BNS, for theft but is unsure whether a new amendment to the BNS applies to the case. The magistrate refers the question to the High Court under Section 435, seeking clarification on the amendment's applicability. The High Court provides an opinion, which the magistrate applies to proceed with the trial. 76 Judicial interpretation in Nader Khan v. State, Delhi Administration, 1975, 2 SCC 406, the Supreme Court emphasized that reference is a mechanism for resolving legal doubts, not for reviewing evidence or facts. The court clarified that only questions of law of substantial importance qualify for reference, ensuring judicial efficiency. Revision under BNSS definition and legal framework. Revision is a supervisory jurisdiction exercised by higher courts, High Court or Sessions Court, to review the correctness, legality, or propriety of orders or proceedings of subordinate courts. Governed by Sections 440 to 446 of the BNSS, corresponding to Sections 397 to 401 of the CrPC, revision ensures that subordinate courts adhere to legal standards and prevent miscarriage of justice. Key features. Nature. Revision is corrective, allowing higher courts to examine the record of any proceeding for errors of law, jurisdiction, or procedure. Scope. It includes reviewing the legality or propriety of findings, sentences, or orders, and the regularity of proceedings, Section 440, 1, BNSS. Initiation. Revision can be initiated suo motu by the court or on an application by an aggrieved party, Section 441. Jurisdiction. Both the High Court and Sessions Court have revisional powers, but the High Court's jurisdiction is wider, Section 440. Limitations. Revision does not permit reappreciation of evidence unless there is a glaring error. No revision lies against interlocutory orders, Section 442, 2. Outcome. The revisional court may confirm, modify, or set aside the order, or direct further inquiry, Section 443. Example. Consider a case where a magistrate convicts an accused under Section 351, 1, of the BNS for criminal intimidation based on insufficient evidence. The accused files a revision petition in the Sessions Court, alleging procedural irregularities. The Sessions Court reviews the record, finds the conviction unsustainable due to lack of evidence, and sets aside the order, directing a retrial. 77 Judicial Interpretation in K. Chinnaswamy Reddy v. State of Andhra Pradesh, 1962, 3 SCR 412, the Supreme Court held that revisional powers are discretionary and should be exercised to correct grave errors causing prejudice. The court cautioned against converting revision into an appeal by re-evaluating evidence, emphasizing the limited scope of revision. Key differences: 1. Purpose. Reference seeks guidance on legal questions, while revision corrects errors in subordinate court orders or proceedings. 2. Initiation. Reference is initiated by the court, whereas revision can be initiated by a party or suo motu by the higher court. 3. Scope. Reference is confined to legal issues, while revision encompasses legality, propriety, and procedural regularity. 4. Jurisdiction. Reference is primarily handled by the High Court, while revision can be exercised by both the High Court and Sessions Court. 5. Outcome. Reference results in an advisory opinion, while revision may lead to modification or reversal of the order. Powers of the Appellate Court definition and legal framework. The Appellate Court, under the BNSS, is vested with extensive powers to review decisions of subordinate courts in appeals filed by aggrieved parties. Governed by Sections 424 to 434 of the BNSS, corresponding to Sections 373 to 386 of the CrPC, appellate powers ensure that errors in law, fact, or procedure are rectified, safeguarding justice. Powers under Section 428. Section 428 of the BNSS outlines the comprehensive powers of the Appellate Court, which include: 1. Reversal or modification of orders. The Appellate Court may reverse, alter, or modify the order, sentence, or finding of the lower court. Section 428, 1. 2. Reappreciation of evidence. The court may re-evaluate evidence to determine if the lower court's findings are sustainable. This includes examining witness testimonies, documents, and other material evidence. 3. Ordering further inquiry. If the evidence is insufficient or the trial is defective, the Appellate Court may order further inquiry or a retrial. Section 428, 2. 78. 4. Enhancement of sentence. In appeals against inadequate sentences, the court may enhance the sentence after giving the accused an opportunity to be heard. Section 428, 3. 5. Acquittal or conviction. The court may set aside a conviction and acquit the accused or reverse an acquittal and convict the accused, subject to principles of natural justice. 6. Suspension of sentence. Pending appeal, the Appellate Court may suspend a sentence or grant bail to the accused. Section 429. Additional powers. Taking additional evidence. Under Section 432, the Appellate Court may take additional evidence or direct the lower court to do so if it is necessary for a just decision. Dismissal of appeal. The court may summarily dismiss an appeal if it finds no substantial grounds. Section 427. Reference to third judge. In case of a difference of opinion in a division bench, the matter is referred to a third judge. Section 434. Limitations. The Appellate Court's powers are subject to certain restrictions. Appeals against acquittals are limited to cases with manifest errors. Section 418. No appeal lies against petty cases or certain summary trial convictions unless the sentence exceeds 3 months. Section 416. The court must provide reasons for its decisions to ensure transparency. Section 428, 4. Judicial Interpretations. Akhlaq v. State of Uttar Pradesh, 1968, 2 SCR 433, the Supreme Court held that the Appellate Court has wide powers to reappreciate evidence but must exercise caution when reversing acquittals to avoid prejudice. In this case, the High Court's reversal of an acquittal was upheld due to substantial evidence of guilt. State of Gujarat v. Mohanlal Jitamalji Porwal, 1987, 2 SCC 364, the court emphasized that the Appellate Court's power to enhance sentences must be exercised judiciously, ensuring the accused is given a fair hearing. Example: suppose an accused is convicted under Section 304 of the BNS for cheating and sentenced to 1 year's imprisonment. The accused appeals to the Sessions Court, alleging that the trial court ignored key defense evidence. The appellate court re-examines the evidence, finds the conviction unsustainable due to lack of intent, and acquits the accused. Alternatively, if the prosecution appeals against an inadequate sentence, the court may enhance it after hearing the accused. 79 Analysis and contemporary relevance. The BNSS refines the mechanisms of reference and revision, retaining the CrPC's core principles while enhancing judicial oversight. Reference ensures legal clarity in complex cases, as seen in Nader Khan, while revision corrects errors without overburdening the appellate system, as emphasized in K. Chinnaswamy Reddy. The limited scope of revision prevents it from becoming a de facto appeal, maintaining judicial hierarchy. The powers of the appellate court under the BNSS are expansive, allowing comprehensive review of facts and law. The ability to take additional evidence and order retrials ensures justice in cases of procedural lapses. However, judicial precedents like Oklak highlight the need for restraint in reversing acquittals to protect the accused rights. The BNSS's emphasis on technological integration, such as electronic filing of appeals, Section 424, and victim-centric provisions, such as mandatory timelines for appeal disposal, enhances these mechanisms' efficacy. Challenges include ensuring uniform application of revisional powers and preventing frivolous appeals, which require robust judicial training. 80 Question 19. Maintenance under Section 125 Criminal Procedure Code. Who can claim maintenance under Section 125 Criminal Procedure Code? Explain. Overview of maintenance under Section 144. BNSS. Maintenance under Section 144 of the BNSS is a statutory obligation imposed on a person with sufficient means to provide financial support to specific dependents who are unable to maintain themselves. The provision aims to prevent destitution and vagrancy, aligning with the constitutional mandate of social justice under Articles 15, 3, and 39 of the Constitution of India. It is a secular and summary remedy, applicable irrespective of religion, and enforceable through criminal courts to ensure swift relief. Section 144 of the BNSS mirrors Section 125 of the CrPC with minor procedural enhancements, such as the option for electronic filing of applications and stricter timelines for disposal to reduce delays. The provision is quasi-civil in nature, focusing on financial support rather than criminal punishment, and is enforced through magistrates to ensure accessibility. Persons entitled to claim maintenance under Section 144(1) of the BNSS. The following categories of persons can claim maintenance from an individual with sufficient means who neglects or refuses to maintain them. 1. Wife. A legally wedded wife unable to maintain herself can claim maintenance from her husband. The term wife includes a woman whose marriage is valid under applicable personal laws or, in certain cases, under customary law. 2. Legitimate or illegitimate minor child. A minor child, below 18 years, whether legitimate or illegitimate, who is unable to maintain themselves, is entitled to maintenance from their father or mother. 3. Legitimate or illegitimate child, not minor, with disability. A child, whether legitimate or illegitimate, who has attained majority but is unable to maintain themselves due to physical or mental abnormality or injury, can claim maintenance. 4. Parents. A father or mother unable to maintain themselves can claim maintenance from their son or daughter. 1. Wife. A wife can claim maintenance if she is unable to support herself and the husband has neglected or refused to provide for her. The BNSS does not define wife explicitly, but judicial interpretations clarify that it includes only a legally wedded wife under applicable personal laws. For example, a Hindu wife married under the Hindu Marriage Act, 1955, or a Muslim wife under Sharia law can claim maintenance. However, a woman in a live-in relationship does not qualify as a wife unless the relationship is deemed a relationship in the nature of marriage under specific circumstances. 81 In Shanmuni Yavi Virendra Kumar Singh Kushwaha, 2011, the Supreme Court held that a woman in a long-term live-in relationship, resembling marriage, may claim maintenance under Section 125 of the CrPC, now Section 144, BNSS, provided the relationship meets criteria like cohabitation and mutual intent. For instance, if a woman lives with a man for several years, presenting themselves as a married couple, she may claim maintenance if deserted, even without a formal marriage. However, a wife living in adultery or who has deserted the husband without sufficient cause may be denied maintenance under Section 144(3). For example, in a hypothetical case, if a wife leaves her husband due to domestic violence, she remains eligible, but if she leaves voluntarily to live with another person, her claim may be rejected. 2. Minor child, legitimate or illegitimate. A minor child, whether born within or outside wedlock, can claim maintenance from their father or mother if unable to maintain themselves. The BNSS emphasizes the child's welfare, irrespective of the parent's marital status. For instance, an illegitimate child born to a couple in a live-in relationship can claim maintenance from the father if he neglects his duty. In Savitaban Somabai Bhartiya v. State of Gujarat, 2005, the Supreme Court upheld the right of an illegitimate child to maintenance under Section 125 of the CrPC, emphasizing that the child's legitimacy does not affect their entitlement. Under the BNSS, this principle continues, ensuring that a minor child, say, abandoned by a father earning a substantial income, can secure maintenance for education and sustenance. 3. Child with disability, not minor, a major child, above 18 years, who is unable to maintain themselves due to physical or mental disability or injury is entitled to maintenance. This provision recognizes the ongoing dependency of such children. For example, a 20-year-old daughter with a severe physical disability, unable to work, can claim maintenance from her parents under Section 144(1)(c). The case of Jagbir Singh v. State of Punjab, 1992, clarified that the disability must be substantial, preventing self-support. In a hypothetical scenario, a son with a mental disorder, unable to earn a living, can claim maintenance from his mother if she has sufficient means, even if he is an adult. 4. Parents, whether father or mother, unable to maintain themselves, can claim maintenance from their son or daughter. This provision reflects the Indian ethos of filial duty and addresses the vulnerability of elderly parents. For instance, an aged mother, abandoned by her children and without income, can seek maintenance from her employed daughter. In Kirtikant D. Vadodara v. State of Gujarat, 1996, the Supreme Court held that a stepmother is not entitled to maintenance under Section 125 of the CrPC unless she is wholly dependent and has no other means. Under the BNSS, this interpretation applies, requiring proof of dependency 82 and neglect. For example, an elderly father with no pension can claim maintenance from his son, a government employee, if the son refuses to support him. Conditions for claiming maintenance. To claim maintenance under Section 144, the claimant must satisfy the following conditions: inability to maintain themselves, the claimant must demonstrate that they lack sufficient means to support themselves. This includes lack of income, property, or other resources, as seen in Rajathi v. C. Ganesan, 1999, where a wife with no income was granted maintenance. Neglect or refusal, the person liable, husband, parent, or child, must have neglected or refused to provide maintenance despite having sufficient means. For instance, a husband earning a substantial salary who fails to support his unemployed wife is liable. Sufficient means, the person from whom maintenance is sought must have adequate financial capacity. In Chaturbhuj v. Sitabai, 2008, the Supreme Court clarified that sufficient means includes earning capacity, not just actual income. The application for maintenance is filed before a judicial magistrate of the first class under Section 144(1). The BNSS allows electronic filing, enhancing accessibility. The magistrate assesses the claim based on evidence, such as income documents or affidavits, and may grant interim maintenance under Section 144(8) to provide immediate relief. For example, a wife seeking maintenance can file an application online, and the court may order interim maintenance pending the final hearing. The BNSS imposes a 60-day timeline for disposing of maintenance applications, subject to reasonable extensions, to ensure swift justice. The maintenance amount is determined based on the claimant's needs, the respondent's income, and other factors like the standard of living, as per Section 144(5). Leading case law. Several Supreme Court decisions have shaped the jurisprudence of maintenance, guiding its application under the BNSS. Bhagwan Dutt v. Kamla Devi, 1975. The court held that a wife's independent income does not automatically disqualify her from maintenance if it is insufficient for her needs. This principle ensures that a wife with minimal earnings can still claim support. Shamima Farooqi v. Shahid Khan, 2015. The court emphasized that maintenance is a right, not charity, and must enable the claimant to live with dignity, considering the husband's financial capacity. Rajanj v. Neha, 2020. A landmark ruling that standardized maintenance procedures, mandating affidavits of income and assets, interim maintenance, and time-bound disposal. The BNSS incorporates these guidelines, enhancing procedural fairness. 83. Consider a scenario where a divorced Muslim wife, unable to support herself, seeks maintenance from her ex-husband, a businessman. Under Section 144, she is entitled to maintenance until remarriage, as clarified in Daniel Latify v. Union of India, 2001, which upheld the constitutionality of maintenance for Muslim women under Section 125 of the CrPC, now applicable under the BNSS. If the husband refuses to pay, the magistrate can enforce payment through attachment of property or imprisonment under Section 144(7). Procedural innovations under BNSS. The BNSS introduces several reforms to streamline maintenance proceedings. Electronic filing, applications can be filed online, reducing barriers for claimants, especially in rural areas. Time-bound disposal, the 60-day timeline for adjudication minimizes delays, addressing the backlog issue highlighted in Rajanj v. Neha. Interim maintenance, Section 144(8), ensures immediate relief, preventing destitution during litigation. However, challenges like inconsistent judicial interpretations and enforcement issues persist, requiring robust implementation to realize the BNSS's objectives. 84. Question 20. Short notes on death sentences and contemporary developments. Write short notes on the following. I. Submission on death sentences for confirmation. 2. Contemporary developments in the Code. Note: I. Submission on death sentences for confirmation. Concept and legal basis. The submission of death sentences for confirmation is a procedural safeguard ensuring that capital punishment, the most severe penalty, is imposed only after rigorous judicial review. Under Section 407 of the BNSS, which corresponds to Section 366 of the CrPC, a court of session imposing a death sentence must submit the case to the High Court for confirmation before execution. This mandatory review protects against judicial errors and upholds the principles of fairness and justice enshrined in Article 21 of the Constitution. The provision reflects the gravity of capital punishment, requiring the High Court to independently assess the case's merits, evidence, and sentencing rationale. The Sessions Court cannot execute the sentence until confirmation is received, ensuring a double layer of scrutiny. Procedure under Section 407. The procedure for confirmation involves several steps. 1. Submission by Sessions Court. After pronouncing a death sentence under Section 255, the Sessions Judge forwards the entire case record, including evidence, arguments, and judgment, to the High Court. Section 407, 1. 2. Stay of execution. The death sentence is stayed pending confirmation, and the accused is typically held in custody. Section 407, 2. 3. High Court's review. The High Court examines the case holistically, assessing the conviction's legality, evidence sufficiency, and sentencing appropriateness. Section 407, 3. It may hear additional arguments from both parties. 4. Possible outcomes. the High Court may confirm the death sentence and conviction, acquit the accused if the evidence is insufficient, commute the sentence to life imprisonment or a lesser penalty, order a retrial if procedural errors are detected, Section 407, 4. 5. Appeal to Supreme Court. Post-confirmation, the accused may appeal to the Supreme Court under Section 415 or Article 136 of the Constitution. 85. Landmark case, Bakhan Singh v. State of Punjab. In Bakhan Singh v. State of Punjab, Air 1980 SC 1325, the Supreme Court established the rarest of rare doctrine, guiding death sentence imposition. The case involved a murder conviction where the Sessions Court imposed a death sentence, submitted for confirmation to the Punjab and Haryana High Court. The High Court confirmed the sentence, but the Supreme Court emphasized that death sentences should be reserved for exceptional cases where the crime's brutality and circumstances outweigh mitigating factors. The court outlined principles for confirmation, including balancing aggravating, e.g., crime's heinousness, and mitigating factors, e.g., accused background. Ensuring proportionality in sentencing. Mandating individualized sentencing hearings, Section 256 of BNSS. This precedent shapes High Court reviews under Section 407, ensuring death sentences align with constitutional safeguards. Practical example: consider a case of murder under Section 103 of the Bhartiya Nagarik Sanhita, 2023, BNS, where the accused brutally kills multiple victims. The Sessions Court, after a trial under Section 248, imposes a death sentence, citing the crime's severity. The case is submitted to the High Court, which reviews forensic evidence, e.g., DNA, witness testimonies, and the accused criminal history. If the High Court finds the crime meets the rarest of rare threshold, it confirms the sentence. Otherwise, it may commute it to life imprisonment, as seen in Bakhan Singh v. State of Punjab, Air 1983 SC 957. Significance: the confirmation process serves multiple purposes. Error correction: it mitigates risks of judicial errors, as seen in Juman v. State of Punjab, Air 1957 SC 469, where the High Court acquitted the accused due to insufficient evidence. Constitutional compliance: it ensures compliance with Articles 14, 21, and 39A, safeguarding the right to life and fair trial. Deterrence and justice: by reserving death sentences for extreme cases, it balances deterrence with mercy. Challenges: despite its robustness, the process faces challenges. 86 Delays: prolonged confirmation proceedings, often lasting years, cause mental distress to the accused, as noted in Kshetrapan Chauhan v. Union of India, 2014, 3 SCC 1. Subjectivity: the rarest of rare doctrines application varies, leading to inconsistent sentencing, as critiqued by legal scholars like Upendra Baxi. The BNSS retains the CrPC's framework but could benefit from timelines for confirmation to address delays, aligning with global human rights standards. Note: 2 contemporary developments in the BNSS. Key contemporary developments: 1. Integration of technology and digital evidence provision. Section 530 of the BNSS permits electronic trials, evidence presentation, and witness examination via video conferencing. It recognizes electronic records, such as emails and CCTV footage, as admissible evidence. Impact: this facilitates remote hearings, reducing delays and improving access, especially in rural areas. During the COVID-19 pandemic, courts adopted video conferencing for bail hearings, a practice codified in the BNSS. Example: in a cybercrime case under Section 77 of the BNS, cyberterrorism, the prosecution presents encrypted chat logs as evidence via electronic means, streamlining the trial. Judicial context: in State of Maharashtra v. Praful B. Desai, Air 2003 SC 2053, the Supreme Court upheld video conferencing for witness examination, a principle now embedded in Section 530. 2. Mandatory forensic investigation provision, Section 176 mandates forensic examination for offenses punishable by 7 years or more, requiring police to collect DNA, fingerprints, and other scientific evidence. Impact: this reduces reliance on oral testimony, enhancing conviction rates in serious crimes. It aligns with global standards for evidence-based prosecution. Example: in a rape case under Section 64 of the BNSS, forensic DNA evidence links the accused to the crime, strengthening the prosecution's case. Judicial context: in Selvi v. State of Karnataka, Air 2010 SC 1974, the Supreme Court emphasized scientific evidence's reliability, supporting the BNSS's forensic focus. 3. Trial in absentia provision, Section 356 allows trials to proceed against proclaimed offenders who abscond, ensuring justice is not stalled. 87. Impact: this addresses delays caused by fugitives, particularly in terrorism or economic offense cases. Example: in a terrorism case under Section 111 of the BNS, an accused flees abroad. The court conducts the trial in absentia, relying on forensic and electronic evidence, pronouncing judgment. Judicial context: the principle aligns with Hussain v. Union of India, 2017, 5 SCC 702, where the Supreme Court upheld proceedings against absconding accused. 4. Bail reforms for first-time offenders provision, Section 479 allows bail for first-time offenders after serving 1/3 of the maximum imprisonment period, promoting rehabilitation. Impact: this reduces pre-trial detention, addressing prison overcrowding and supporting fair trial rights. Example: in a theft case under Section 303 of the BNS, a first-time offender is granted bail after 4 months, facilitating reintegration. Judicial context: in DK Basu v. State of West Bengal, Air 1997 SC 610, the Supreme Court emphasized custodial safeguards, reflected in Section 479. 5. Victim compensation and restorative justice provision, Section 396 mandates victim compensation schemes, ensuring financial and psychological support. Impact: this shifts focus to restorative justice, addressing victims' rights alongside punishment. Example: in a case of grievous hurt under Section 117 of the BNS, the court orders compensation for medical expenses, aiding the victim's recovery. Judicial context: in Laxmi v. Union of India, 2014, 4 SCC 427, the Supreme Court advocated victim compensation, a principle codified in Section 396. 6. Fur and mandatory fur registration provision, Section 173, 1, mandates fur registration for cognizable offenses, including zero furs, allowing complaints to be filed at any police station regardless of jurisdiction. Impact: this enhances access to justice, particularly for marginalized communities. Example: a victim of assault in Delhi files a zero fur in Mumbai, which is transferred to the appropriate jurisdiction, ensuring prompt investigation. Judicial context: in Lalita Kumari v. Government of UP, 2014, 2 SCC 1, the Supreme Court mandated for registration, reinforcing Section 173. 88. Critical analysis: the BNSS's contemporary developments offer significant advancements but face challenges. Strengths: the integration of technology, forensic mandates, and victim-centric provisions align with global best practices. Bail reforms and zero furs enhance accessibility and fairness. Challenges: Advocate Kushal Moore critiques Section 225, which allows accused hearings before cognizance, arguing it may delay proceedings. Limited plea bargaining, Section 289, restricts non-trial resolutions, as noted by legal scholar S.P. Seth. Infrastructure gaps, such as forensic labs, may hinder Section 176's implementation. Judicial guidance: cases like Sheila Bars v. State of Maharashtra, Air 1983 SC 378, emphasized timely justice, urging robust implementation of BNSS reforms. Future directions to maximize the BNSS's potential, the following are recommended: strengthening forensic infrastructure to support Section 176. Expanding plea bargaining under Section 289 to reduce case backlogs. Establishing timelines for electronic trials, Section 530, to ensure efficiency. 89.